to mention one upgradation. My lord, I have
Well, under compelling circumstances, I am mentioning one matter, my lord. This matter was lordship filed during the vacation. An interim order on the demolition notice was issued by the Colonel Coordinate Bench. Interim order was subsisting till 20th June. Thereafter, lordship, that interim order was renewed time to time by your lordship's court. But on 30th of June, my lord, suddenly this unfortunately matter got dismissed for default. My lord, immediately the restoration application has been filed. That has been mentioned. That was mentioned on 7th of July. My lord, during the pendency of this, my lord, today at 12 p.m., the demolition is going to be effected, my lord. I got the notice, my lord, on Friday. So I did not have any scope to mention this matter, my lord. Kindly take it at some time before prior to
not at all.
12:30 because
You can be ignorant about
no, sir, I immediately filed it, my lord. Immediately
Well,
after dismiss for default, within one day, I filed it.
it
The
will
application
come-
and
it will
mentioned
come
the
in due
matter.
course, sir.
My
Give
lord-
your slip. It will come in due course. Give
My
your
lord,
slip.
due course, my lord, only thing is the urgency.
Slip, sir. We'll see.
Lordship, I'll give that notice to that effect, my lord. Let it appear tomorrow, lordship.
We will see that.
Lord, otherwise, lordship, this petition will become
You
infractious.
have a sanction plan?
I have everything, lordship. That I can satisfy your lordship on that.
We'll see. We'll see.
Lordship, kindly,
We will see, sir.
lordship, by this time, if they demolish, they complete the demolition, because time
Whatever-
is given from 12 to 5 today.
Whatever demolition has taken place will take place. We'll see that. Don't need demolition in this rain.
Lordship, kindly.
The corporation is so inclined to demolish in this weather. Anyway,
my lord,
I've taken your slip. We'll see that.
My lord, I'll
similar prayer for similar prayer for upgradation. I have served the municipality.
Justice Chanda before the regular bench. Justice Chanda before the regular bench. No leave today, sir. Tomorrow the court is sitting from tomorrow. No leave today. No, sir. No. Sorry, sir. Sorry, sir. Not allowed. Next.
Lordship,
One correction needs to be made, my lord. Order sheet dated 1/7/2025.
Make the correction. Give it to the
Lordship for release.
The correction.
For release.
what release?
Lordship, petitioner is deep trouble, my lord. The order which has been filed in the contempt proceedings of the municipality, that has been challenged before Lordship in second time.
Yes.
Lord, I have several occasions, my lord, try to come before Lordship to mention the matter. Also, I filed the
No
one
release.
urgent application.
No release. All right.
Lordship,
Yes.
that is up to Lordship, because I have deep trouble.
Whatever it is.
Being an advocate now, I am alleged that I am taking bribe by other side and not doing.
All right. Matter
anything.
will come in due course.
Lordship, kindly have a look, my lord, kindly consider the prayer to release the matter, because unless
Release, no release. Prayer heard, rejected. If you want upgradation,
upgradation, my lord, I am doing upgradation now.
Your Lordship, item number 82 of monthly list, Your Lordship. I have challenged an action of KMC, Your
give
Lordship.
your slip, sir.
Kindly
My lord, need to mention, my lord, under compelling
Give
circumstances,
your slip.
my lord,
sir.
circumstances is that
Upgradation.
now the illegal construction is going on
Upgradation.
in such a way, my lord, it is blocking my ingress and egress, my lord.
Ingress and ingress, go to the civil court, unauthorized construction,
They
give
have
your slip.
blocked without any sanction plan. They are constructing the building, my lord. I will only take my lord 1 minute because
Give your slip, sir.
my lord.
My lord, actually, my WPA number 28166 is listed in the monthly list 1886. My petition number 1 is very senior, 77-year-old, and respondents are actually unauthorized, doing the unauthorized construction. I have submitted the. Kindly please take it.
Your Lordship,
Give your slip.
Your Lordship, one matter is for inclusion. Mallet had been pleased to direct that a report to be filed by the department, Mallet.
Give your slip, madam.
Mallet, this is for inclusion. And Mallet, there is
Your
one
Lordship, I be permitted to mention one matter for upgradation.
Give your slip.
Mallet,
Your
there is
Lordship,
one
it is on, my printed slip is on the way.
Very good.
Your Lordship,
Very
I'll,
nice.
Lordship, I'll submit it within 10 minutes.
Mallet, this is another matter, Mallet, this is little urgency. Mallet, the urgency is that Mallet, now false complaints are being made against me.
Give your slip, we'll see that.
Lordship, this is for upgradation. Your Lordship, the petitioner happens to be a school-going girl, college-going girl. After the filing of this case, she has been threatened by the opposite parties.
Threatened by the opposite party, go to the police.
She has went to the local PS thrice, but this is the first time
Take
again
an
she has
action,
been
go
asked.
to the
Does
regular
she
bench.
take this application first? No, this is for unauthorized construction. She has complained against this. Thereafter,
Unauthorized.
during the pendency, she has been.
May I have a
Lordship,
And
may I
Lordship,
have a-
Lordship, Lordship, one learned advocate purchased a property in favor of his wife. That is not muted by the local council, local municipality. Lordship, two similar matter, badly suffering prolonged year. Lordship, kindly consider accommodate
Give your slip.
1468. I have given slip 1468 and 1469
Right.
monthly list.
my lord,
Lordship, similar matter, only direction
There is
mutation.
no preferential treatment for lawyers. All right?
Lordship, only
If he is member of the bar, he should understand how the court functions.
Lordship,
All right.
prolonged years happening.
Prolonged years, there are
vendor-
many people who are waiting here for prolonged
Mutation,
years.
mutation is
All
there in
right,
favor
sir,
of
you have
vendor.
given your slip, we'll
Lordship,
consider it.
give a slip given.
my lord, with
Yes.
Immediately, it is filed during the vacation, demolition case, Miller. The said developer has constructed one floor unauthorized, and I am the landlord. The notice is given. 18th is the date of.
Very good.
my lord,
Lordship, this
my lord,
is
in this
for.
ma-
Yes, madam.
Lordship, this is for against the rent bill. Like I am the trade license owner of a bakery, but the opposite parties have brought in the rent bill in the name of the same, like in the same name, in the name of my bakery. I have made a complaint. They have done the inspection, but again they are carrying on the business in the same name.
Have you challenged their trade license?
Lordship, we have already challenged. We have also filed a case under 420 and forgery, which is pending. But Lordship will take this matter. And one more matter,
Lord-
Lordship. This is also for upgradation. That is 0 plus. They have already constructed 6
They have
floor without
decided
sanction
today
plan.
all the matters will be upgraded.
Lordship,
my lord, the urgency, my lord, in this matter, the urgency is, my lord,
Yes.
that I have submitted my proposed building plan more than 7 months ago, but still,
Give your slip, give your slip.
May I be permitted to mention one matter for upgradation, my lord?
Give your
Pension
slip,
matters,
madam.
your lordship,
High matters, my lord. A similar order has been passed by your lordship, my lord.
So how many posts are there that you are filing Shahika's matter? There were only 10 or 15 posts for Shahika's, right?
Yes, my
So many matters have been filed.
lord. 3 matters, my lord.
Limited post. I don't know how you are filing these cases.
Your Lordship may
Give
be
your
permitted
slip.
to mention one matter for upgradation. It's a illegal
Give
construction.
your slip.
Madam, I am seeking matters kindly
Much
to
obliged.
mention the matter for upgradation. The
Lordship, I beg to mention one upgradation matter.
grateful
Give
to
your slip, madam. Give your slip.
Much obliged.
All right.
But I beg to appear on behalf of the petition.
রিটায়ারমেন্ট করেছে, ভলেন্টিয়ার রিটায়ারমেন্ট করেছে 5/7/2013 তারিখে, এবং কাটোয়া মিউনিসিপ্যালিটিকে বলেছে যে তুমি এর সমস্ত সার্ভিস বেনিফিট ইমিডিয়েটলি দিয়ে দাও, কিন্তু কাটোয়া মিউনিসিপ্যালিটি আমাকে খুব হ্যারাসমেন্ট করতে দিচ্ছে না, আমাকে একটার পর একটা খুব
What is
মানে
the case number? What is your writ petition?
আমি কেস নাম্বারটা নিয়ে এসেছি স্যার,
Give the case number.
কেস নাম্বার
কাগজ দাও। কাগজ দাও।
আমি বড্ড কষ্ট পাচ্ছি স্যার ফ্যামিলিতে,
Give your case number, sir.
কোর্ট করে দেখো।
Give your case number, sir. Give your case number. Yes, yes.
My lord, on the last occasion, my lord, there has been a error, my lord, in recording of the name of the learned.
Lord, actually, I was appearing for the developer, supporting the petitioner also. Lord, I prayed for time on the last day because 2 matters were taken up one after another.
No correction.
Correction.
Necessary correction we made out. You have already indicated.
My lord, indicate করেছো তো? Yes, my lord.
What is the
And-
correction?
and
In order sheet. What is
Order
the
sheet, my lord, order dated 2nd of July 2025, my lord.
My name has gone on as my lord for the petitioner. Lord, I am appearing, my lord, and their name has not gone. I am appearing, my lord, for respondent number 427.
Rupsa Shrimani for petitioner.
Yes.
That's how you wanted.
Yes.
That's you.
Yes, sir.
And 427. I am for 427.
চিঠিটা দাও।
All right. Mr. Chakravarti for 427.
Yes. Kindly correct that
All
otherwise.
right. Necessary correction we can.
My lord, only one more humble prayer, my lord. The petitioner is not willing to proceed with the writ petition. We have got a, my lord, he has written a letter.
Hmm? This is for correction, sir.
Very well, my lord.
Tomorrow, give your,
I do not want to, I am appearing for the petition.
you do not want to press the petition anymore.
And let the matter be dismissed as withdrawn. And this is my letter.
Carry the now. This learned counsel for the petitioner states that he does not wish to pursue with the writ petition. He has handed over a copy of the instruction received from his client. The same is taken on record. The present writ petition is dismissed as withdrawn.
My lord, in this matter, I am appearing for the state lordship.
Matter settled.
Perhaps not the petitioner cannot afford any more an expensive lawyer. That may be the reason. It's very difficult to afford Mr. Bhattacharya.
He looks happy. His expression tells me he's happy.
Morning,
It's difficult to afford him. Maybe that's the
He
reason.
has come all the way to withdraw the matter. I can understand how important it is.
Certain things cannot be told in court.
Lordship, in this matter, I am appearing for
For
the
such able juniors. Huh?
Yes.
Money is here.
Despite
He's
that,
here.
I
Still
was,
you had to come to withdraw the matter.
I was roped in. The,
Mr.
all the
Bhattacharya. We all know why you're.
Oh, man.
These are some privileges.
Absolutely.
These are some special privileges.
তোমাকেও দিচ্ছি দাঁড়া তোমার কত নম্বর আছে জানো আমাদের এই দাঁড়া, কত নম্বর
Lord, I'm appearing for the petitioner, praying for a correction, Your Lordship.
My lord, I am appearing for the municipality, my lord.
Lord, at para 2,
All right. Necessary changes will be carried out.
Lordship, there is one more correction, Your Lordship, which has not been specified in the slip, Your Lordship. The road name has not been specified, which is Calcutta Road. It was specified in the writ petition. In para 2, line number 5. Holding number, it will be 450, and the road name has not been specified. Calcutta Road is the specific location.
That's okay. That would make.
Also, because in that plot, there's multiple street names, so it will be easier to identify the plot location.
Your petition. This is what it is there in the petition. Which page is the petition where you are
Lordship, in page 6, para 2. It is written as in bracket Calcutta Road. Para 2, Your Lordship, holding number 450 within bracket Calcutta Road.
Done.
Grateful.
My holding number.
My lord, I am for the municipality, my lord.
All right.
Yes, sir.
Ms. Bawal, your appearance is marked.
Lordship, I am for the state in this matter, Lord.
I'm for the petitioner.
My lord, it's my application for intervention, Lordship, where there's a dispute between Mr. Arindam Banerjee was appearing for the petitioner.
So I'm still appearing, beg to appear, my lord, by virtual mode to assist your lordship, lord.
My lord, we wanted.
Why you're not here? You're enjoying the weather.
My lord, a little bit of glitches in the car, my lord, it will be fixed in half an hour.
All right.
We are the tenants in the property. Lordship, property tax dispute between the petitioner and the corporation. Premises put under padlock. I run an online platform for groceries called Big Basket, Lordship. My perishable goods and some furniture, etc., have been stuck inside. I just wanted to remove them. That's all. And be added as a party respondent in the application.
Mr. Mitra, right? Yeah. Mr. Mitra was supposed to take instruction.
Yes, my lord. Sorry. No, my lord, there are other 5 writ petitions filed. Writ petition filed by the tenants. Now, my lord, we had given notice to the recorded owner. He did not respond. We passed an order adjudicating the valuation. That was also communicated. Thereafter, no steps taken to make the payment. Hence, my lord, we proceeded in terms of section 219, read with 221.
No, but they're not saying that. This is an impediment application filed by the tenant. He's asking that his good, can he remove his goods?
What he wants is to get his goods taken out from the godown. My lord, in terms of the law, 219, 220, we have a claim on these goods. These are movable properties for realization of my taxes.
Distress warrant issued.
Distress warrant already issued. Your lordship hears it out, and along with those 5 writ petitions, I'd be giving my lord's court officers the numbers.
They are all connected to this?
Yes, connected to the same property. Like where he is a tenant, the others are also tenant. They have filed independent writ petition. Only difference is he wants to be added in this writ petition as a party.
My lord, may I clarify the factual aspect?
Yeah.
My lord, we were not aware of these proceedings. My lord, we've come to know, we were not aware of these proceedings. We've come to know, that is why we've gotten added. The other thing is primarily my goods are all movable properties. I do not understand this claim because it's strictly between the owner's property, owner's movables, owner's immovable property. We are the tenant. We have perishable goods there. Some of it is already gone. I do not know what claim they could possibly have. I'm just trying to retrieve whatever I can retrieve. That is in any case.
Yes, claims. I'm just reading it, or your lordship doesn't require it also. It shall be the lawful for any officer or other employee of the corporation to whom a warrant issued under this chapter is addressed to distrain wherever it may be found in any place in Kolkata, any movable property belonging to the person within brackets liable subject to the following condition, exceptions and all that there. And the other thing, what I cannot take, the clothes, the necessary wearing apparels, beddings of the defaulter, his wife, children, and other cooking and eating utensils, tools, and books of accounts.
Except that,
My lord, I can put into service the distress.
And my lord, going by the section,
it on the outer wall.
it is only the person who is liable. Admittedly, I am not the person who's liable. And secondly, property of the defaulter. Admittedly, I am not the defaulter. There is no dispute over this. This is an admitted fact.
This is your can 1, Amarchand Agarwal.
Lordship.
So you are like a family of 17 people.
17 people. We are the
That is the writ petitioner, Lordship.
We are the writ petitioners, my lord. The family of
and
17
we are the
people,
interveners.
Which is your can?
Can 1 is
Can 1.
And one, Lordship.
Who are you in can 1?
My lord, I am innovative retail. I'll tell you, Lordship, the full name. We are, Lordship, innovative retail.
Innovative retail.
Lordship. We run this remote grocery delivery platform.
What I understand,
Big Basket.
my client, this is Big Basket.
Yes.
My lord, we are neither the defaulter, never put on notice, not claimed by the corporation to be person liable.
You are not
We've
a
not
payer
been
of tax.
exactly,
How can there
which
be
is why
defaulter?
that section does not apply to us, because it clearly says it's only the defaulter and the person liable to pay tax and no one else.
My lord,
I'm relying on my learned friend's submission.
Mr. Mukherjee, you file your reply to the application.
yes.
My lord, in the meantime, Lordship, nothing will be left of my goods.
Let them see if he is raising an objection.
My lord, but
Then I have to
Let
consider the
them pay
application.
the apportioned share of tax. I will open it.
my lord,
within
the
24
KMC
hours.
hasn't claimed that I'm liable
Your
to pay.
lordship
My lord,
give
File-
me
let
an
them file
option.
the reply.
Let him pay the apportioned share of tax. I will, within 48 hours, I will.
my lord, how he has
Own
not claimed that
respect
I'm
of their
liable to pay. I don't understand. Follow my learned friend's
That is
submission.
the argument which he is making. That any goods, anything which is left in the property, they have a
Lordship.
right over that property.
My lord, that is admittedly not the case as per the section itself. It is the property of the defaulter and the property of the person liable to pay the
Let them
tax.
file the reply, sir, before I decide.
My
the
lord, then
application.
very short time,
My lord,
Lordship.
only
Kindly,
one,
because
I had only one humble submission, my lord. This point may not be, is no more res integra. A division bench of our Honorable High Court has decided, my lord, in Mackinnon Mackenzie versus Calcutta Municipal Corporation. Mr. Mukherjee is aware of the judgment. And that has subsequently been followed by a single bench judgment of Justice Amrita Sinha, in which, my lord, it has been held that under coercive actions, my lord, for attachment of movables, that occupiers' movables cannot be attached. Now that I beg to apprise your lordship of these two. If your lordship kindly keeps it, my lord, if your Today I am a bit handicapped. If your lordship keeps it tomorrow, my lord, I can, my lord, assist your lordship, my lord. It is a very short point, my lord, where
Then
my
we'll
lords
have
can-
it tomorrow.
Great, great.
Tomorrow. Not
Mr. Mukherjee is aware of these two judgments. He may just want to make his submissions on them.
what is this?
This is
Mr.
Mackinnon Mackenzie
Mackinnon
versus
Mackenzie.
Calcutta Municipal Corporation. Lord, the citations I'll give you, lordship, lord, as soon as I arrive. Please give me 45 minutes, lord. I'll come and I'll give your lordship's officers the citations.
Just give the citation.
And that's been followed also repeatedly, also by an honorable single judge.
Great.
Alright.
Great.
ঠিক আছে কালকে হবে
No, this is
I beg to appear on behalf of the Barrackpur municipality, my lord.
Yes.
Private response?
Yes. Now, my lord, so far as this case is concerned, my lord, the petitioner before your lordship, my lord, is the owner of the property in question. Now, my lord, what happened, my lord? The certain land, my lord, what classified as bill, my lord, that is, my lord, water body. Now, the private respondent number 6 and 7, they are the, my lord, local councillor. Ward number 16 and 17 of the, my lord, Barrackpur municipality. Now, my lord, respondent number 8, 9 and 10, they are, my lord, illegally encroach my land, making construction, filling up my dobas, my properties, water bodies. Well, I moved the civil court. Civil court will have passed an order of injunction. The order of injunction is still will not continuing. Despite that, the construction is going on. I made an objection to the Barrackpur municipality. Chairman is not taking into matter. Kindly see what kind of construction. Kindly see the first civil court's order. Page 42.
Yes.
May I just place him, Lord? The lordship will kindly first few paragraphs, short paragraphs, then will the case of the plaintiff in nutshell. As you also got it. The case of the plaintiff in nutshell is that the Taraprasad Sahu was a recorded owner of the suit property, that is Schedule A and B and C, and has recorded his name in the office of the BLNLO on 12/11/1974. After the death of Taraprasad Sahu, his son, namely Birendra Prasad Sahu, became the owner of the suit property, and on 17/7/2000, after the death of Birendra Prasad Sahu, the plaintiff and pro forma defendants became the owner of the suit property. On 10/5/2005, the defendants brought some materials of the suit property and intend to raise boundary wall in the Schedule A property and Schedule B property, trying to fill up by pouring debris. And Schedule C property also excavated and raising constructions. The defendants have no right title interest in the suit property. Therefore, by filing this injunction application, the plaintiff prays for an order of injunction, restraining the defendants and his main and agent, and undertaking any construction work over the suit property by changing the nature and character. During the hearing in support of the of his case, advocate for the plaintiff submitted the certified copy of RSROR, print out the copy of the information sheet, and xerox copy of the certificate and such. On hearing the submission of the learned advocate of the plaintiff and on perusal of the entire material on record and documents submitted before this court, the plaintiff has a strong promising case to go for trial. So, if in this situation an order of injunction is not granted, plaintiff may face severe loss and injury according to the balance of convenience and inconvenience lies in favor of the plaintiff at this stage. Now, order the identity order of injunction filed by the petition is allowed. The defendants are hereby restrained from undertaking any construction work of the suit property by changing the nature character till 14/6/2024. I will have this compliance order 39 rule 2 and all these things. I will have this interim order from time to time extended. I will have kindly text me. I inform the officer in charge of the concerned police station. First information I have given at page 43. Now, subsequently also, I also inform the chairman Barrackpur municipality at page 44.
Yes.
Now, if lordship can you see page 44, I intimated the chairman Barrackpur municipality stating all these things. The title suit is also filed, and the construction, they are making the construction, they have no right title interest in respect of the property in question, and requested the Barrackpur municipality to take render necessary help for implementation of the order passed by the London Civil Court. Now, next page, page 45. Your lordship would find, I also intimated by writing letter dated 11/6/2024, intimated the Commissioner of Police, Barrackpur Police Commissionerate. Now, next page onwards, page 46 onwards, your lordship would find that I have annexed the photographs. 46 to 52, these are the photographs, they are filling up
the water body. And my lord, they are also making construction, my lord. And page 54, 52, my lord, you will also find, my lord, the more or less constructed. Page 52. Now, my lord, again, my lord, I requested the chairman, page 53 of the Barakpur municipality, as well as the commissioner of police and officer in charge. By letter dated 12th August 2024, they look here, these things are going on, kindly take necessary steps, as because they don't have any right title interest over the property in question. And my lord, everything has been done by the, my lord, councillor of ward number 16 and 17 of the ruling political dispensation. I don't want to make any comment about this, my lord, but fact remains, but my property has been encroached by somebody else, making construction. Not only that, my lord, water body is being filled up. These are my submissions.
Yes.
My
You are
lord,
for the corporate.
I only Barakpur municipality, not councillor, my lord. This is the case, my lord, encroachment between the parties, civil suit is pending. We are not implementing agent. They requested me to implement the order. How we, my lord, implement? Police can implement.
How is the construction taking
Once the
place?
boundary wall, there is no permission is required for
This is not
boundary
only
wall.
boundary walls, sir. Do
Boundary.
you think this is boundary wall? The picture shows boundary wall.
What, my kindly page 46.
See the picture on page 47. Is it boundary wall, sir?
47, my lord.
Is it boundary wall?
They cost, my lord. We have there is.
So what are your instructions?
My lord, I got, my lord, Friday brief from my learned friend, my lord. Kindly, my lord, allow me 2 days time. I shall take my details, my lord, report from the municipality.
Come back to the court. You're officer of the court first.
Yes, my lord.
You don't work for councillors.
No, no, I am supporting, not supporting, my lord.
Day after tomorrow.
Day after tomorrow.
Come with a report.
Report.
And don't try to tell the court.
No.
You're not blind that we don't see construction. Boundary wall. This boundary wall.
Well, I shall take instruction.
Next.
I am appearing here the petitioner, my lord. Petitioner, I am praying for northeast wing, my lord. As the petitioner advocate is ill, my lord.
Sorry?
Petitioner advocate is ill, my lord. Due to his illness, he is unable to come at this.
I appear for the private. I am not opposing this prayer because of the illness. The only thing, there is already an order of demolition. This is the process how the matter is otherwise being prolonged.
To do, Mr.
Any. थोड़ी खराब हो क्लियर ना इसे तो always that's the ground ये ताते एक कोड भी yes advocate is ill unauthorized construction বলেছি বাবা বলেছি তাহলে শুনে গেছে
What do we do? The lawyer is
kindly note that.
Any day.
Take it up next.
Any day, that is convicted.
For our past.
When do you want?
Next Monday, my lord.
Monday, my lord. Possibly there would be some disruption.
Monday or Wednesday. Wednesday, my lord.
Subject to your lordship convenience.
Yes. Yes, ma'am.
If possible.
Subject to my lord's kind convenience. Kindly record one order.
My lord, for
28th.
28th. Monday.
Learned counsel for the proxy counsel for the Mr. So-and-so appears. Proxy counsel so-and-so appears and states that the main arguing counsel is indisposed. Let this matter be listed on. He prays for a short adjournment.
I appear for the respondent in his report.
Yes.
28.
Item number 6, I am respondent, my lord.
No, 5 he is for the petitioner. I am appearing.
5 you are for the petitioner.
I am the petitioner.
Grateful, man.
Do the advocate report. Advocate report.
But item number 7 at the first instance, I must confess before your lordship, this matter was upgraded. At our instances, proper notices to all of the parties could not be served. May I come back tomorrow? Because Friday we have mentioned and handed over the slips. The exact date, my lord, may I come back tomorrow by upon giving?
Sir,
them
you
notice?
mention it, we upgrade it, but you don't serve the party.
Though my one of my adversaries appearing.
So what is the point of upgrading matters?
My lord, may I come back
Monday
tomorrow?
morning, it's a circus over here. Everybody is jumping over us to get the matters listed. When the matters get listed, you have not even served the party.
Matter is really urgent in this is unauthorized construction.
Sir,
obstructing- but
This
I cannot
poster
improve my
only has unauthorized construction.
My lord, I cannot, at the first instance, I have said, my lord, may I come back tomorrow, giving them notice?
This is very unfortunate.
My lord, it's entire my responsibility. May I come back tomorrow?
Tomorrow,
Not good.
day after tomorrow. Day after tomorrow.
Yet, my lord.
And this petition as it is, sir, let me tell you, your petition is not maintainable.
With regard to this, I will make my submission on the last occasion. On the earlier round of litigation, my lord, we have, in pursuant to your lordship's leave, we have withdrawn the writ petition on the plea that earlier round there was a writ petition.
But there's
who
no
is in action.
There's no liberty in there.
No liberty right, my lord. But in this particular case, what happens, the statutory authorities are duty bound to take certain action. Civil disputes are going on. My lord, we made a representation. They have not. And in the meantime, by this process, a 3-story structure has been constructed without keeping any boundary wall, obstructing my drainage, my sewerage, your lordship.
Give them notice first. We'll see.
Grateful. If sanction plan is there,
So for the respondent.
Respondent number 5. There are
The
10,
rest-
there are 10 respondents.
the respondent municipality will come and say, my lord,
I
that
have
is
come
not the
after
case.
seeing the cause list, my lord, I have come.
Tomorrow.
I know plus.
Day after two, sorry. Day after two. Yes, Mr. Banerjee.
I am for the petitioner. Allegation is of not 2 additional floors without sanction.
No, I am for the
Private
private
respondent
respondent.
has used an affidavit. Report has not been filed because there was a direction not to file report. And I have to not use an exception to that. But admittedly, 2 additional floors. Private respondent says subsequently after construction, those have been regularized.
But the
It cannot be
allegation
done.
is I am
No.
right now constructing 4 additional floors. That is the allegation in the writ petition, your lordship.
No, one of the floors money has been paid, extra floor, but
Two floors admittedly have been regularized. Which are not constructed
other
as
2
per plan.
floors self-demolition notice has been issued. And immediately demolition will be done as the demolition has not been done by the party.
Under which provision of retention fee has been accepted for 1 floor.
They should have
That is
challenged
not-
that retention
which-
order.
No, they are now disclosing.
We have to disclose it when it is.
Let them disclose the order, my lord, because since they are filing the report, the order by which, because unless they show under which provision they have done it.
Yeah, Mr. Banerjee, what is this retention fees? Under which provision do you?
Retention fees was accepted in the year 2018 as the at that point of time it was being accepted, but finally it is not accepted now. At that point of time,
At that
I
point of time?
must say that under no provision, that I can say, but it was accepted at that point of time. The petitioner moved this honorable court. Retention fees was accepted in the year 2018, and petitioner moved before this on 2025. Maybe due to some rivalry, but in any matter, I cannot support it, the retention. But it
No,
was
then
it
after
was
that-
done on 2018. Deposited retention fees was 14/8/2018.
What has been there must be some orders which have been passed by this court. as far as retention fee is concerned?
No, no,
How has
Milord,
this court looked?
177 has been amended to some extent and minor deviation can be regularized subject to regulations or rules. No rule has been framed by them.
I have a very specific question
My
to ask Mr. Banerjee.
My lord.
They are taking retention fees. They have done it in several matters. Is there any authority or judgment which concerns retention fee where it has been held to be legal or illegal?
Illegal. No, it cannot be done. There's a judgment. I'll produce that. Today I don't have it. There's a division bench judgment which says that the extra floor cannot be held to be a minor deviation, cannot be retained.
All right. Report filed by the respondent claims HMC is taken on record. Learned counsel for the petitioner seeks 2 weeks time to file his 1 week, 2 weeks.
No, 2 weeks.
Your Lordship, I will also file an exception because they say it's 1 floor. They have taken for 2 floors, Your Lordship. I will also file an exception.
Learned counsel for the petitioner as well as respondent number
5.
5. Seeks and is granted 2 weeks time to file their exception to the said report. List this matter after 4 weeks. Mr. Banerjee, you must be aware.
I am aware that at that point in time, retention fees was.
No, but how has the court looked into this?
Pardon?
How has the court looked into this? Any
No
authority?
judgment of Howrah Corporation which says it cannot
Probably the court, I think, no quarter has been passed for that reason in the year 2018, probably.
From 18 till date, no order has been passed.
18 to 2025, we have not taken.
No, either the court would have condoned your action or they would have rejected your action.
If your lordship so directs me, I will.
I just want to listen what has.
I will return that.
And
I will take.
Predicament then.
I will take it.
Madam, I'm just trying to understand the law. I'm not passing any order.
I apologize.
I just want to understand.
I support this.
I shall come back with the judgment. There's a division bench judgment.
My lord may not keep it in the judgment, but I will not support this. কখন হচ্ছে?
11.
In this matter, Lordship, item number 9, I am on behalf of the petitioner, Lordship. Lordship, with your Lordship's permission, I am filing affidavit of service.
For the corporation.
For the municipality. Lordship, the brief fact of this, Lordship, may I be permitted to mention the brief fact? Lordship, the brief fact of this instant matter is that the petitioner participated in a tender and Lordship 10% amount was paid first to build one stadium, namely Netaji Sadan. And after that, Lordship, this 10% amount was also taken by the municipality. After completion of the work, when the petitioner claimed that the total amount, then the municipality is saying that within time the project has not been completed, which is completely false, and due to that very reason the amount cannot be given. And Lordship, one thing is very, very important, that for the purpose of this project, sufficient space is also required, and municipality knew it very well. But Lordship, no sufficient place was given in favor of the petitioner for the purpose of mixing the raw materials. And Lordship, present situation is that the work has been completed, but municipality is not paying the amount, and due to that very reason, the petitioner sent representation, and after receiving the representation, the municipal authority is sitting tight over this issue, Lordship.
Well, Lord, in this writ petition, only 10-15 paragraphs are there, but no pleadings. What is the amount they have received from us? Not a single word. Just they have stated by a representation dated, my lord, 9th of August 2023, that we get 1.5 crore from you. Extra money which we have, my lord, costed. So because the costing is high, so you have to pay 1.5 crore to us. That is the only pleading in this petition. Nothing more, nothing less.
Show it, sir, from the record.
If your lordship kindly see.
Lordship, paragraph number
Paragraph
9.
8 and 9.
What is there? What is the amount? What is the total amount? What have you? Why should they pay 1 crore 50 lakhs? Nothing is there.
Lordship, in that event, Lordship, I humbly draw your Lordship's kind attention and attendance also on page number 14.
But there is no pleading with regard to this page number 14.
Chairman, Lordship, kindly see the finance officer passed, but Lordship, the concerned municipality has not taken, Lordship. Kindly see the note of page number 14. Kindly see the footnote of page number 14, Lordship.
These are all disputed question of fact. You are filing a writ petition to recover your money. Not even an admitted amount. No completion certificate given to you.
Completion certificate has not been provided, Lordship.
That's what I'm saying. Then how do you quantify the loss or the gain or the amount? Nothing is here. Go before the civil court, sir. File your suit for.
Lordship, in that event, Lordship, kindly give a leave to file a supplementary affidavit
No need.
But
No
pleadings are
supplementary
developed.
affidavit is required.
How will develop the pleadings?
Nothing is required.
Nothing is. How did you got the order, work order? What was the estimated amount? How much you have received? Nothing in details.
Nothing is here in this writ petition.
Lordship, I have annexed all documents, Lordship. Lordship, some documents, Lordship, will be filed.
The petitioner.
Lordship, in that event, Lordship, may I
Might
be
be
permitted
present.
to say only one thing, Lordship?
Yes, sir.
Lordship, kindly give a direction to consider my representation. For the purpose of consideration of representation, my representation may be allowed or may be rejected. So, Lordship, kindly give a direction to consider my representation as per the prayer of the writ petition,
You
Lordship.
have to make out the case.
The petitioner, in the present writ petition is aggrieved by the inaction of the respondent municipality in failing to take any decision on his representation dated 9/8/2023 to release the amount pending bills of the petitioner. Outstanding amount to release the outstanding amount payable to the petitioner in relation to the construction of the stadium bracket mein Netaji Sadan. Full stop. It is the case of the petitioner that he was awarded a tender by the Bansberia municipality in the year 2015 under the Member of Parliament Local Area Development Scheme. He claims that he had completed the said project, full stop. But there was a delay since the petitioner was not given adequate space to carry out the ready mix working, full stop. Petitioner claims that he has suffered huge monetary losses due to the not providing of adequate space for carrying out the construction activity, full stop. The petitioner has preferred the present writ petition, being aggrieved by non-grant of the outstanding payment as well as non-grant of outstanding payment, full stop. The present writ petition, learned counsel for the respondent states that nowhere in the writ petition the petitioner has stated what was the cost of the construction of the stadium or the amount which the petitioner has already been paid. The petitioner has only stated that he has suffered monetary losses but has failed to demonstrate from the writ petition any loss which on what account he has suffered the losses, full stop. Learned counsel for the respondent states that these are all disputed question of facts and the same cannot be adjudicated in a writ petition, full stop. This court has heard the arguments advanced by the counsel for the parties and has perused the materials on record. The tender was floated sometime in the year 2015. Petitioner claims to have completed the tender, though belatedly due to inadequate space being provided by the respondent municipality for carrying out the construction. Though the petitioner has nowhere stated in the writ petition that how he has suffered losses, except a bare bold statement that he has suffered losses to the tune of 1,50,00,000 lakhs, full stop. The petitioner has not even put on record you have not put the tender document or anything, huh?
Nothing.
Has not even put the tender document to show what.
Lordship, in that event, Lordship, kindly come to page number 79, Lordship.
Tender document to show what was the total amount of the tender and what payments has the petitioner received till date. full stop. There is even the completion certificate which would have shown that the petitioner has completed the work is not on record, full stop. There is no way for this court to ascertain the amount which could be pending for the completion of the work, since the petitioner has not placed any document
Lordship, page number 79.
quantifying the amount which needs to be paid by the corporation. The petitioner has, what is this, page 79?
Lordship, kindly, the refund of the mobilization advance per instruction from District Magistrate Hooghly. Lordship, initially I said that the advance amount has been taken by the concerned municipality. Lordship, from page number 79, it is reflected, Lordship.
The petitioner has only placed a document wherein a refund of mobilization advance has been mentioned, which does not reflect any amount which is pending as far as the respondent corporation is concerned, full stop. Since this is a contractual dispute between the parties, and that the loss suffered by the petitioner has not been quantified, full stop. The disputed amount cannot be looked into by this court, since the same pertains to disputed question of facts and cannot be adjudicated by this court under the writ jurisdiction, full stop. In view of the said facts, this court is not inclined to exercise its discretionary jurisdiction under Article 226 of the Constitution. The writ petition is dismissed.
And give to President.
Want to carry out the construction work. Ready next one after that. Just carry out the construction.
Municipal. Full not the municipality, please. Yes.
My lord,
At
10
last,
I am for the petitioner.
as regard
11,
my lord, I am for the petitioner.
11, my lord, I am private respondent.
Today Malda municipality is also present. 10 and 11.
Yes.
My lord, last occasion I have submitted that the private respondent, rather a person allegedly got a promotion. Subsequently, when I was directed to show cause, I explained my case. Then municipality withdraw his promotion and promoted me to that post and demoted the private respondent to my lord as a in the post of clerk, which is demotional post. Now, my lord, my main grievances is that since my appointment, I am performing my duty in my promotional post, however, getting salary of my earlier post. And private respondent, though discharging his duty as a demotional post, but getting, my lord, salary of promotional post. Without, my lord, unchanging his salary, municipality is doing that. This is my grievances because the fraction amount which I supposed to got since 2019, according to the municipality, I am not getting. Till today, even I, my lord, annexed my salary slip, my lord.
Yes.
And it has been recorded in the last.
As regards item number 11,
I'm the petitioner, my lord. In my writ petition, my lord, I made him a party, but this is very unfortunate, my lord. In his writ petition, he, my lord, doesn't made me a party. However, my lord, the petitioner, my lord, in my case, my lord, initially the petitioner was appointed, my lord, in the year 1997, my lord, in the post of Group D. Thereafter, Lordship kindly see page 26, my lord, Lordship kindly straightway come, my lord, page 26.
Yes.
Lordship bottom, my lord, actually, this is,
Yes.
my lord, Shopon Shorkar, Lordship kindly see, my lord.
Yes.
Shopon Shorkar, it would be my 33, my lord. Left hand side, some, my lord, Lordship kindly see, right hand side, clerk.
Yes.
This is the petitioner, this is the scale of pay. My lord, before that, my lord, I am reading, my lord, order. As per adopted resolution of the chairman in council held on 10/10/2011 and approved at the meeting of the board of councillors held on 15/10/2011, the following employees will enjoy the mentioned scale of pay and will fit in the following basic pay with effect from 1/10/2011. So, my lord, with 1/10/2011, my lord, from Group D to clerk, my lord, my service was confirmed. Now, Lordship kindly see, my lord. My lord, thereafter, what happened, my lord? I was promoted, my lord, from the post of clerk to, my lord, in the post of tax collector. And it is, Lordship, Lordship kindly see, my lord, page 29. Because of my performance. Page 29, annexure P5. May I read it, my lord? Page 29. My lord, appointment of promotion to the post of tax collector in Old Malda municipality. The undersigned is highly pleased to inform you that as per GO number so and so, dated so and so of the Director of Local Bodies West Bengal, Joint Secretary of the Government of West Bengal Municipal Affairs Department, you have been promoted to the post of tax collector from the post of clerk Old Malda municipality in the scale of pay rupees so and so, along with DA, HRA, medical allowances as admissible from time to time with effect from the date of joining of you in the respective promotional post.
Now, kindly take page 45 parallelly in my
let me submit.
Kindly take page 45.
Say that.
Let me submit. Then, Lordship, kindly see the next page, my lord. Page 13. This is the approval.
Yes.
This is the approval, my lord. Approval of appointment on promotion under Old Malda municipality. With reference to the above, the undersigned is directed to state that the governor has been pleased to accord approval under section 54(3) of the West Bengal Municipal Act 1993 as amended to the appointment on promotion of the following employee to the post as mentioned against him under Old Malda municipality in the usual scale of pay and allowances with effect from the issuance of the order. Shopon Sharkar, clerk to tax collector. This is the approval of DLB when, my lord? 12th December 2019. So, my lord, since 2001, 1/10/2001, my lord, I have been working as tax collector, my lord. Now, Lordship, kindly see, my lord. All on a sudden, my lord, page 32.
Yes.
After so many years of service in the post of, my lord, tax collector, and that has been accorded, the approval has been accorded by the Director of Local Bodies, my lord. All on a sudden, Lordship, page 32, annexure P8. This is the impugned order, my lord. Seeking clarification against promotion of Sri Shopon Kumar Sarkar. This has been, my lord, issued by the Deputy Secretary, Government of West Bengal to the Director of Local Bodies. My lord, subject seeking clarification against promotion of Sri Shopon Kumar Sarkar, tax collector under Old Malda municipality. With reference to the above mentioned subject, I am directed to request you to take necessary action on the following on the matter of Old Malda municipality. Number 1, revocation of promotion order in respect of Sri Shopon Kumar Sarkar issued by DLB order number so and so dated 12/12/2019. Second, revoking the overdue within next 6 months from the salary of Sri Shopon Kumar Sarkar as the employee still in service by way of short deduction from salary, or the incumbent may deposit the amount in the concerned treasury linked bank through treasury challan. Overdue related to previous financial years is to be deposited in the HRA so and so, my lord, and overdue related to current financial year is to be deposited in the HRA so and so, or through a combination of both. 3, taking up the matter of awarding promotion to Shaman Chakraborty, that is my learned friend's client, my lord, to the post of tax collector, subject to fulfillment all requisite criteria as per extant rules and government orders. Well, first of all, my lord, the excess amount, my lord, it cannot be, my lord, refunded. As because, my lord, there are so many orders of our Honorable Supreme Court as well as our High Court, my lord. If there is no fault on the part of the petitioner, so the, my lord, that deduction cannot be arise, my lord. Now, Lordship, kindly see, my lord. Thereafter, the next page, my lord, page 33. My lord, without following any rules, my lord, without issuing me any notice, how this, my lord, this letter can be issued by the Deputy Secretary whenever, my lord, I have been working, my lord, in the promotional post since 2019 with the approval of the Director of Local Bodies. Now, Lordship, kindly see page 33. What the Director of Local Bodies, my lord, wrote to the Chairman in connection with the subject mentioned above. Enclosed, please find here with the number so and so. This is the, my lord, letter number of the Deputy Secretary issued 14 August 2023, issued by the Deputy Secretary UD and MA Department, which is self-explanatory. You are directed to comply with the order of the Senior Deputy Secretary, UD and MA Department, as mentioned above, immediately and send an action taken report to this municipality. Now, Lordship, kindly, my lord, skip, my lord. Lordship, kindly page 35. Page 35. My lord, though that letter was issued by the Director of Local Bodies, my lord, to the, my lord, Chairman, now the Lordship, kindly see, the Chairman says, my lord, in pursuance of letter number so and so, issued by the Director of Local Bodies, West Bengal, this is to clarify that Sri Swapon Kumar Sarkar recommends from tax collector to clerk from dated 12/12/2019. Now the incumbent are allowed to draw pay and allowances in the promotional post in terms of the relevant rules, West Bengal Service ROPA rules 2009 and 2019 from the date of joining in the promotional post. At present, his salary calculation prepared by estimated department. So, my lord, again, my lord, I am getting the salary in the promotional post. Now, Lordship, my lord, this is a very vital and important, my lord. Lordship, kindly see page 36. This is the letter, my lord, issued by my learned friend's client, my lord, in the year, my lord, 22nd August 2014, my lord. My lord, kindly pardon me, my lord. This is not translated, my lord. This is a Bengali letter, my lord. My lord, he declares that, my lord, though I am entitled to get the promotion, but I will not get any promotion because of my illness.
Because of your
illness. Don't give me any promotion because my illness. His own. Yes, he has written, my lord, when, my lord, 22nd August 2014. So the vacancy.
Kindly match the signature with the vocal.
Yes, all right, no problem. This is not my handwritten. This is not my handwritten.
What is the source?
And not only that, my lord,
Kindly
this has
my
been.
lord, this has not.
Kindly let me allow, sir. Please. My lord, no. I have annexed this. Everything I have annexed. My lord, and this was, my lord, received by the executive officer, my lord, of the municipality. So, my lord, whenever this declaration has been made, my lord, in the year 2019, my lord, I got the promotion in the post of, my lord, tax collector. And thereafter, Lordship, kindly see, the municipality, my lord, what happened? The municipality, my lord, practically, Lordship, kindly see page 40. Page 40, my lord.
Yes.
So the municipality state that order issued by the DLB, my lord, still I am getting the salary in the post of tax collector, my lord, and my lord, without following any rules, without following anything, my lord, all on a sudden, after, my lord, 5 years of service in the promotional post, my lord, they are saying, my lord, no, you are, again, you are going back to the, in the post of clerk. And my lord, after, my lord, so many years, my lord,
Now he is filing this writ petition in the year 2024.
They are mentioned in page 41. Page 41, para 1. The councillor's letter. This is the ground.
Yes, my lord.
Page 41, para 1.
Yes. This is the ground according to my learned senior's client.
No, even
Issued by the chairman.
My lord.
the chairman has taken the same ground.
Yes. Then my lord, kindly come to the order passed by the my lord board of directors of local body. My lord, kindly take my lord read petition so that I can refer the pages.
My lord, kindly ask my learned friend to at least provide me a copy, but I don't know, my lord, what allegation they
Why
are.
you have not made him a party?
Because my lord, my answering respondent is the municipality because the
But
money has
still you should have made him a party.
But I
if
paid
your
him a
lordship
party.
granted me because I am the person against whom order has to be passed in your read petition.
Still you should have made him a party.
My lord, if leave granted, I can add him as a party and sabak. My lord, kindly take note of the first. My lord, take page 36 according to
You make him a party, we'll have it tomorrow, day after tomorrow. Day after tomorrow. Make him a party.
That's why on the last occasion, we pointed out that this writ petition should be heard together. Otherwise,
Yes, yes.
the private response is necessary.
My lord, one line I just whatever documents he is relying, I was directed to SOCOS to give my reply that whether that letter is written by me. I categorically told them that the signature has been.
We will see the
Then
stand of the
entire thing has been clarified and I
They are
got
for the municipality.
Yes,
What is this all hodgepodge you have done?
kind of, if my I'm praying for 4 weeks for giving the reply because
Let him make a party first. We'll have it on Wednesday.
My lord.
Learned counsel for the petitioner seeks to implead respond number, implead Mr. Mr. Shamal Chakravarti as a party respondent to the presented petition. Liberty is granted.
Sopon Sarkar has to be made party in
Sopon
Samal
Sarkar,
Chakravarti
whatever.
in item number 10. My lord, I am handing over him a copy. I am just making him.
Wednesday.
Great.
Grateful. I'm grateful.
Thank you.
My lord, I'm appearing for the state.
Give your appearance.
Item number 11, my lord.
All hodgepodge.
Great.
My lord, kindly record my name, my lord.
Well, my lord, I am for the
Grateful, my lord.
Item 11 for the state. Shabnam. Both are connected matters. इसमें both are आप इसको ऐसे कर लो ना. The writ petition so and so shall be heard along with writ petition so and so. In writ petition so and so, learned counsel for the petitioner seeks liberty to add so and so as a party respondent to the present proceeding. Liberty is granted. Let this matter be listed on. All right.
My lord, this is a group 2 education matter, my lord. Your lordship, my lord.
I appear for the state respondents.
My lord, by filing this, my lord, I am seeking in implementation of an order passed by the Honorable Apex Court. Partly it has been complied with, partly, my lord, it hasn't. Now, my lord, we are, my lord, contractual.
I'll come back in 5 minutes.
Very well.
Lord, the petitioner before your lordship.
I appear for the respondents.
It's a contractual part-time teachers. Now, my lord, they filed writ petitions, my lord, seeking equal pay for equal work. Now, my lord, by a coordinate bench, my lord, was pleased to take up this writ petition, and my lord, considering, my lord, State of Punjab versus Jagjit Singh's case, my lord, reported in 2017, volume 1 SCC, page 148, my lord, directed the state to extend the benefit of minimum pay for equal work. Now, this judgment and order was challenged by the state by preferring an appeal. Now, the appeal court, my lord, modified the judgment and order passed by the learned single judge, and my lord directed the state to pay from 2010 to 2013, and then further directed the principal secretary, my lord, to consider their claim from 2013 onwards, my lord, upon, my lord, considering the records, my lord, to be produced by the school. Now, the state, my lord, thereafter, my lord, we preferred an SLP, not we, my lord, those petitioners, my lord, preferred an SLP, and we filed a transfer application. Now, these transfer applications were tagged with the SLP. Now, this original judgment, my lord, was passed, my lord, in respect of two persons, one Anirban Ghosh and one Borun Kumar Ghosh. Now, our transfer applications were tagged with that SLP. Now, the Honorable Supreme Court, my lord, took up all the matters, and, my lord, directed the state that you consider and comply with the directions passed by the Honorable Division Bench, and same relief will be given to the persons, my lord, who filed these transfer applications. The state, my lord, thereafter, my lord, extended an opportunity of hearing to Anirban and Borun Kumar Ghosh. Their case was rejected, and state also, my lord, pursuant to the Honorable Division Bench direction, my lord, released the financial benefit from 2010 to 2013. Now, this financial benefit, my lord, was also given to us. Only thing is, my lord, that the personal hearing, which is required to be extended to us, that has not been done. This is only our grievance, my lord. My lord, may I just place, my lord, the Honorable Division Bench order, which starts at page 20 of the writ petition, my lord.
Yes.
My lord, relevant is at page 52. This judgment and order was passed in respect of the writ petitions filed by Anirban Ghosh and Borun Kumar Ghosh. My lord, kindly consider page 52, the last line, my lord, last two words, in the event the writ petitioners made a representation before the Secretary School Education Department in justification of basic pay for the period from April 2007 till December 2009 and after 24 December 2013, demonstrating discharge of similar duties within a period of 4 weeks after the lockdown is relaxed and the normal functioning of the school and colleges are restored, the Secretary shall consider such representation within a period of 3 weeks thereafter upon giving an opportunity of hearing to the writ petitioner as well as the concerned schools, my lord. Now, my lord, this is the one direction, and there is another direction, my lord. Your lordship, kindly consider, my lord, 3-4 lines thereafter, my lord. The school authority shall under an obligation to produce the attendance register of the class routines for the aforesaid period before the secretary, along with any other materials as may be directed in order to enable the secretary to decide the claim of the petitioners. It is needless to mention that the secretary shall be guided by the principle laid down in this order and shall not deny the claim of the petitioners merely because of their initial contractual appointment in view of the fact that the school education department had taken a decision not to sanction any additional posts for these higher secondary schools which were running with part-time contractual teachers since 2002 with the effect from April 1st, 2007. The secretary shall pass a reasoned order which shall be communicated to the writ petitioners and the concerned school within 2 weeks from the date of the order. Now, this is the order, my lord, passed by the Honorable Division Bench. Thereafter, my lord, Anirban Ghosh and Borun Kumar Ghosh, my lord, preferred an appeal, preferred a special leave petition, my lord. Kindly consider, my lord, page 57, my lord. My lord, state also, my lord, preferred an SLP. my lord, before that, your lordship kindly consider page 55 first. My lord, the last line, the court passed the following order, issue notice, tag with SLP number 2809 of 2021. Your lordship will find, my lord, all the writ petitions were tagged with this SLP. Now, the order passed by the Honorable Apex Court is at page 57. My lord, in the middle, your lordship will find petition for special leave petition and transfer petitions number from 1288 to 1297 of 2022. My lord, paragraph 2 is relevant, my lord. Having regard to the fact that the impugned judgment was passed on 3rd September 2020 and the same has remained stayed in terms of the order passed by this court on 20th September 2021, it is deemed appropriate to direct the state government of West Bengal to make compliance of the impugned judgment within a period of 3 months. From today, the relief granted in the said judgment shall also be extended to all similarly placed private respondents, including the interveners, impleaders who have moved applications in the present petitions.
Yes.
Then transfer petitions were quoted in terms of the order passed in petitions of special leave to appeal, number such and such. The transfer petitions are disposed of along with the pending application. Now, my lord, thereafter, my lord, at page 61, onwards, my lord, I have annexed these representations were made to the Secretary Department of School Education, my lord. These representations are pending. However, my lord, the Secretary, my lord, decided the case of Anirban Ghosh and Borun Kumar Ghosh. Now, our representations are pending, my lord. And my lord, at paragraph 15, my lord, pursuant to Honorable Division Bench judgment and order, I have stated that state partially, my lord, complied with. Kindly consider paragraph 15. The petitioner state that in terms of the judgment and order dated 16 July 2024, the respondent released the following arrear salary for the period from 28 July 2010 to 24.
15 of what?
My lord?
Where are you reading?
I'm sorry, my lord. Page 12, paragraph 15. Extremely sorry, my lord. My lord, paragraph 15, page 12 of the writ petition. My lord. May I place, my lord? The petitioner state that in terms of the judgment and order dated 16 July 2024, the respondent released the following arrear salary for the period from 28 July 2010 to 24 December 2013, which was transferred to their respective bank accounts. Then page 13, my lord, I have indicated that the amount and, my lord, the date when it was transferred, my lord. Therefore, my lord, partially, my lord, it has been complied with. But the second issues, my lord, that the case is required to be considered by the principal secretary, that has not been done. This is the, my lord, small issue.
My lord, I'm grateful to my lord, but he has pointed out
yes,
partial compliance at page 15, page 12, paragraph 15, lordship has got it. Now, my lord, my instruction is that yes, my lord, what is submitted by my learned friend on the other side, that the only 2 petitioners were heard, not the transfer petitioners. Before the onwards, they have not been heard.
no,
Now,
but
my
then
lord,
similar relief has been extended to them also.
my lord, they
you
have
see
got the
page
benefit, monetary benefits they have got. Only thing they were not heard. But these 2 other SLP petitioners, they were heard and their claim was rejected. Well, they want pay parity with the regular teachers. That's the, my lord, the dispute. Now that was heard, but 2 were heard, but the transfer petitions were not heard. That is their grievance. Now, my lord, I have got a copy that has not been annexed to this petition, but I can place on record by you an affidavit or report, whatever lordship directs. But because this is not part of the petition, my lord, here, my lord, we will find that admittedly, my lord, they have got the benefits, but only thing, my lord, and 2 SLP petitioners, they have been heard and their claim for, my lord, this what is called this equal pay as regular teachers was rejected. Now, my lord, this subject to correction, my lord, I will have to check whether these transfers were heard or not. So to that extent, my lord,
that is the only grievance he has, that they have not been heard.
That's it, my lord. If that is not heard, they will be heard. But my lord, should I come with a report, my lord, or an affidavit?
See, sir, even if you come with the instruction, written instruction, that you are ready to extend the benefit which has been extended to Barun Kumar as well as Anirban,
Yes,
In that case, we can dispose it off
yes. Now, my lord,
on the basis of the instruction. See, you have not extended the benefit to both of them.
no,
They have also been rejected.
yes.
There's also whatever the fate.
They will have
Only
the same fate.
consideration, nothing else.
They are not asking for anything else.
Yes, only consideration.
So, my lord may do this. Your lordship may, I want to place on record, my lord, the order of 15th of January
It won't be
2025.
relevant. We can cut short the issue if you are able to give this instruction or get the instruction that they can also be heard. They have a very limited prayer.
Yes, yes. That to that extent, what I'm
Very limited prayer.
very
So they are
limited
not
prayer.
getting into anything else.
But my lord, should I place on record the order or reasoned order
Sir,
passed in
won't-
compliance with the order?
It won't be required. Whatever reasoned order you have
Very well,
passed in
I'll
terms
come back
of
to you.
Mr.
I'll
Barun and
come
Mr.
back to you,
Anirban,
Lordship,
similar thing you can do with them also. They are not saying.
that they should be given.
Yes,
Correct.
They should be considered.
consider.
That's
Yes,
all.
that's
All. They are only asking for a hearing, which you have given to the other two petitioners.
they want the hearing.
Since they are interveners and impleaders, they have not been given the same benefit.
The petitioners before Lordship.
Though at page 58, the Supreme Court has clearly said that they should also be given the similar.
They should be heard according to order, and there is well, is no
You come with the instruction, we'll finish it off.
আপনি যদি
Very well, as your lordship directs. Or your lordship may, if not already heard, they should be heard. Let them,
Yes.
matter be disposed of here and now.
No, then in that case, then I will need an affidavit from you.
Yes. That is that.
If I have to pass an order, then I need an affidavit from you.
I'll come back with the instruction. Lord.
That's better.
That
will cut short the issue.
Yes. That's it.
All right. At the request of the learned counsel for the parties, let this matter be listed on.
Any day, subject to my learning senior.
A week's time, I think we'll do. A week's
Hey.
time we'll.
Can we have it on Friday?
Friday. I'll try, but the lordship, the government department will have. I'll
But
try
this is just instruction, you know. You just have to get the instruction.
Very well. I'll try. I'll Friday. Very well.
So then we will have it on the 18th. 18th. इसको ना top में ही रख लेना. Top. हाँ, top 5 matters में करके instruction के लिए. हाँ, ठीक है. First 10 matters में डाल दें. First 10.
Grateful.
Friday.
It will appear for orders or under any particular.
No, for instruction, then I'll pass an order. On your instruction will pass because you have to.
No, I have to, my lord. And it has been done in respect of two. They have been excluded. I don't know how, but they have been excluded. As I find from his submissions.
Correct.
Grateful man.
Lordship grateful.
All right, it's my application for restoration, my lord. But it was dismissed, my lord, on 18th of March 2025. By my lord, and my lord, within time, my lord, it was filed, my lord. 7/4/2000.
Municipality. You don't have any objection to restoration?
Well, I have no objection. I depend upon your lordship's consideration, my lord.
But if your lordship also hears the matter, my lord, on merit, my lord, I will, my lord, be obliged. It's very short matter, my lord.
That's what.
We can take up a hearing.
My lord, it will take some time because, my lord, according to their claim, my lord, cause of action arose in 2019. I have not yet gone before the municipalities whether the completion certificate has been issued or not.
But it is
My lord, it will take some. Your lordship can give me a time for filing affidavit, my lord, because it all along is disputed fact, my lord.
No dispute, but I know, my lord, they are
My lord,
document.
Sir, why decide his representation?
representation consider.
Yes.
My lord, that I cannot. But your lordship can give me the liberty before the municipal authority. If there is an demand, municipal will intimate to them. Get.
But in that represent and consider, my lord, they can show, my lord, what is their difficulty, my lord. But I have annexed, my lord, their document, my lord, their calculation only, my lord.
Your
That-
representation is page 43.
My lord, my lord, your lordship, come, my lord, to page 21 and 24, my lord, of the petition, my lord. My lord, this is
Where is
where
your
from, my lord, will form.
representation?
Representation. The presentation, my lord, is, my lord, starting from 27, my lord, it's 43, 45. Any
43, that's what I asked
43,
you.
my lord. 43, my lord, and another representation, my lord, is there, my lord, for giving me the earnest money, my lord. That is, my lord, at page 22, my lord, of my supplementary affidavit, my lord.
Which representation you want to be considered?
Both, my lord.
Modern.
May I file this as supplementary? my
Modern
lord?
trading company is the original, but here he has been made by some Botra. But the name of the Botra has not.
No, what is the supplementary affidavit? I have not asked for any supplementary
My
affidavit.
lord, this I have prepared, my lord, just, my lord, because one representation was missing, my lord. What happened, my lord, there was a period, my lord, for guarantee period of 5 years, my lord. That was also over, my lord. Now, my lord, I am also entitled to my get back my EMD money, my lord. That representation was not there, my lord, in this petition.
Sorry, sir. That
Because
can't
then,
be
my
a
lord,
part. Give it back.
Page then 43, my lord.
Page 43, right? Take down. This is an application. First for can label. This is an application. Can is there? Can one?
But kindly, if possible,
Can
but
only on the
Yes.
it's a dismissed matter. तो फिर मैटर कैसे आ गया? Basically, application is restoration. This is an application for this is an application filed by the petitioner for
if I may, my lord.
restoring the present writ petition for restoration. Application filed for restoration. Learned counsel for the respondent states that they have no objection if the matter is restored. Full stop. In view of the submissions made by the in view of the reasons stated in the application and the concession granted by the respondent, the application is allowed. Can so and so is restored. Full stop. With the consent of the parties, the present writ petition is taken up for hearing. Full stop. I'm just deciding the representation.
No, my lord. My submission is, my lord, modern trading company is the original owner, but here application is some Botra, who is the
My
proprietor.
authorization is
But
fine.
the name of the Botra has been recorded in municipal office, my lord. All along the modern trading company.
Then they will decide that, my lord.
No, that is the way. I am only drawing your lordship answer.
You reject the representation.
My lord. Grateful. Give them nice.
Two representatives, my lord, if possible, P4 also page 27, my lord, thereby the calculation is given, my lord. Page 27, my lord, the calculation is given, my lord.
Yeah, I'm not getting into calculation. I'm
No,
just
I am asking, my lord, to represent to be considered, my lord, page 27 and page 43.
27 is a calculation, sir. I'm not
That
going
is the
getting into
advocate's letter.
calculation.
47 is the advocate's letter. That is not representation.
Very well, my lord, then page 41, my representation, my lord, page 39, my representation, no problem.
Advocate.
Advocate.
স্যার দেখুন আপনি কি বলছেন মাই লর্ডের কাছে
আচ্ছা তাহলে মডার্ন কোম্পানি পেজ 27 মানে মাই
Only that.
রিপ্রেজেন্টেশন পেজ 27 is my representation. Twenty-seven, 28 এগুলো সব আমার রিপ্রেজেন্টেশন আছে 29
যা আছে করে দেবেন দেখে করে দেবেন
আমার সিনিয়রের নাম হচ্ছে প্রশিক্ষণের অর্ডার দিয়ে দেন
কি বলছে দেখি শুনুন
These are all petitions which are contractual in nature.
That's
You
what
keep
I was
filing-
going to show to your lordship 21, my lord. That is their document, their calculation, where they have allowed.
Take
my lord,
evidence, my lord.
allowed
That's why it is not a writ code, my lord. Your lordship kindly say to the civil code, my lord. Just now, your lordship passed an earlier order.
Is page 21. my lord.
Item
21
number
is-
9, my lord.
There was no document, sir. Here at least there is some document.
Page 21 is bill form, my lord, submitted by them, my lord. By their document in which, my lord, kindly see the petition name, Madan Trading Company is there, my lord, and at the bottom, my lord, payment allowed is also.
All right,
Page 21.
take down the petitioner, comma, by way of the present writ petition, comma, is aggrieved by the inaction of the respondent in failing to release the outstanding payments due to him for the successful completion of the work awarded under contract number WBMAP/ULB/SRMP/NIT 29 dated 5/3/2019, dated 27/5/2019. Full stop. Learned counsel for the petitioner submits. You are the client. You are in this matter.
No.
Learned counsel of the petitioner submits that the petitioner duly completed the work assigned to him, comma, work assigned to him, and comma, thereafter submitted all the bills amounting to rupees 81,07,399 and 59,31,482 respectively. Full stop. Despite considerable period of time, the respondents have not cleared the outstanding payments of the petitioner. Full stop. Petitioner states that he has made several representations. However, comma, no response. Representation, comma, however, comma, no response have been received till date. Full stop. Learned counsel for the respondent corporation states that they are ready and willing to decide petitioner's representation dated 20th December 2022. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the said statements, this court directs the respondent. Which one? Respond number? Who, chairman or the?
Money, 2 and 3.
The chairman, respond number 2.
2 and 3.
To decide petitioner's
2 to 5.
representation dated 22/12/2022 within a period of 12 weeks.
12 weeks, 3 months. Yes, get full.
Within a period of 12 weeks from the date of communication of this order in accordance with law, comma, करते रहना, after affording an opportunity of person hearing to the petitioner, comma, by way of a speaking order, full stop. With the above direction, the presented petition is disposed of. The contents are not admitted. No affidavit.
It present disposed of, my lord.
Writ petition.
Grateful, man.
এসে গেছে।
Lordship, this is for restoration of the petitioner which was
Yes, Mr. Manager.
which was taken off for default. In fact, I had informed the court when it was in the
All
the
right.
determination of Justice Kaushik Chandra.
This is an application filed by the petitioner. This is an application, this is a restoration application filed by the petitioner, full stop.
Copy আমাকে দেবেন original.
Done it, counsel, for the respondent.
লালমোহন কাছে তো
KMC.
আগে যে ছিল বিডিও
Yes.
Corporation
HMC. HMC states that he has no objection to the presented petition being restored. Full stop. For the reasons stated in the application, as well as the concession made by the council for the Havra Municipal Corporation, the presented petition is restored to its original position.
My lord, one submission, my lord, a copy may be.
I'll do that. I'll do.
Read petition, copy of the.
Give a copy of the.
I'll do that. Much honored.
Much of.
Lord, I am appearing on behalf of the respondent number 4, private respondent.
For the state.
On the last occasion, my Lord, your Lordship, kindly see that writ petition has submitted. There is one plan, structural plan, there is no other plan. But it is totally incorrect submission. There are two plans. One is, my Lord, structural plan, another is, my Lord, water sewerage plan. My Lord, kindly see. And there it has been specifically, my Lord, mentioned that the water reservoir should be, my Lord, made in the front side of the house, plot of the land, but they have done it, my Lord, back side of the, my Lord, house. That's why, my Lord, water is percolating, and my bedroom is totally overflowed.
Water percolates down or percolates up?
Percolated above in my bottom. I am staying at the ground floor.
Sir, reservoir is
First floor, my Lord. Peculiar enough, reservoir is in the first floor. And
May I
that's
say, Millard, this is a case, Millard, alleging unauthorized construction by the Millard private respondent.
not
Now, Millard,
writ petitioner, not
okay.
writ petitioner.
The writ petition. Now, Millard, I am appearing for the corporation. I mean, the main and agents of the corporation have gone there, Millard, to visit the Millard local site, Millard. They have found that a reservoir has been constructed. Now, Millard, we have given opportunities of hearing, and accordingly, reasoned order was passed. The commissioner directed the petitioner before your lordship to demolish the construction as it is made violating the sanction plan. Now, on the last occasion, when the matter was taken up by your lordship directed the corporation and the respondent to Millard to take on instruction, Millard, as to whether there is a provision of construction any reservoir in the plan. Millard, I have the instruction with me. I have the copies of the plan available with the
I have
records of the corporation. May I place it, Millard? This is, Millard, the plan. Take to the as per the plan, the reservoir ought to have been constructed on the front portion of the building. Whereas the reservoir has been constructed at the back side of the building. Your lordship is there, Millard, the carved portion, Millard, where the word road type 6 is written.
Yes.
There is, Millard, a mark.
Yes.
In the name water tank.
Yes, yes.
That is the, Millard, provision in the plan where the reservoir ought to have been constructed. On the right hand side, there is written AH 258.
Yes.
There is an arrow. That is the ferrule from where the corporation is providing, Millard, water service. So the reservoir, instead of, Millard, constructing the reservoir in the front side, they have constructed the back portion, Millard, the right hand side. Millard, this is the area where they have constructed. And in the plan, the reservoir is marked over here to be constructed.
So, my lord, we have come to a conclusion that the entire construction is unauthorized. And accordingly, reason order has been passed. Anyway.
And kindly see what is the condition of the room also. My lord, I can show the.
So he's saying that the reservoir is constructed on the first floor. How can it be on the first floor?
My lord, it
Could
cannot
not.
be, my lord.
Cannot be. It is illegal.
I have the photographs, my lord, just now early in the morning I received. So I could not take a printout of it. Moreover, my lord, one thing I would like to point out, the construction is being is made on the side open mandatory space. It ought not to have been encroached by any type of construction.
Ground floor plan no, first floor plan.
যে ইনস্ট্রাকশনটা আছে আমাদের অফিসাররা বলছে এটা গ্রাউন্ড ফ্লোরের প্ল্যান
Reservoir cannot be at the first floor with
তাই
ground
যদি
floor.
হয় তাহলে
Put this on record.
well I have mailed a copy of the inspection report signed by the officials of the corporation. May I place it before your lordship?
Sorry.
I have
And
a copy of the inspection
My
report.
lord also
It is
consider.
dated 12th of July. May I place it on record, my lord?
Yes, and my lord also consider the rules, my lord, building rules, before construction of building as per sanctioned building plan, the plot holder must submit his sewerage and water supply plan for sanction.
আচ্ছা, আচ্ছা। ছেড়ে দিন।
Illegal.
You put this with affidavit.
My lord. Let it be. হ্যাঁ আমি যখন এফিডেভিটটা দেবো তখন
একটা কপি দিয়ে।
Demolition has taken place or?
Miller, we have demolished the structure. Thereafter, Miller, pursuant to the order of the Honorable Coordinate Bench, Miller, we have once again constructed the reservoir, Miller.
Again.
At his own
At
cost.
our own cost, at the cost
No,
of the corporation.
Milord, as per order, I
বলেছিল না দশের পুলিশ
constructed
খরচা করে দিতে।
groundwater reservoir. And Milord, we'll say their communications, municipal corporation commission, groundwater reservoir.
আচ্ছা, আচ্ছা, আচ্ছা।
How it is situated on the first floor of the building, I cannot understand. And I will seek leave from the court to inspect.
I am
personally.
also not able to understand that how is it, he says there is water seepage.
Water seepage, my lord.
Miller, I am not in a position to assist you.
Your officer is here. Come here. What is your name?
Pump is
Yeah,
my lord.
wait a minute.
My lord.
You are the?
He is the law officer of the corporation.
Ask the executive engineer.
The
how-
pump is first floor.
Pump is first.
Pump is-
Reservoir is not on the first. How can the reservoir? That's what I was
Reservoir-
asking you,
Yes,
sir.
sir.
You were so
Reservoir is
confidently you are making this statement.
My lord. Reservoir is ground floor, pump is first floor, and my lord, it is
There's a
overflowing.
difference between
Yes.
pump and
Yes, yes.
reservoir,
Yes.
please.
Yes. My client is present.
Then perhaps what has happened, he has made some extension of the ferrule from the front portion to the back portion, Miller, and storing water inside the reservoir. And from there, Miller, he is collecting, Miller, pumping the water after. That is the Miller.
But so far the sanction plan is concerned, it should be my lord, constructed in the front side of the plot, but he has done it backside of the plot. And he my lord, submitted that there is he will be waterless if the reservoir will be shifted from there. My lord, another water connection is there, and ferrule is there. My lord, therefore there is no question of any waterless.
My lord, I shall again remind your lordship to come at page 25.
Yes.
Clearance certificate in respect of.
Sir, it is very clear from the sanction plan that you have constructed in deviation of the sanction. You were first making the statement that in the sanction plan, there is no position which indicates a reservoir. That is not correct. Your statement is not correct.
That is with me, my lord.
They have, sir, they have also given.
I had shown my learned advocate on the last date, wherein it is not, the spot is not clear.
He is showing the.
Sir, he is showing the plan where the spot is very clear.
That document is not with me.
I don't, sir,
Yes,
don't make wrong statements to the court.
no, my lord.
All right?
My lord, I have this plan with me, structural.
Sir,
plan with-
your reservoir is in the back side where it should be in the front side. It's an admitted position. You cannot change it.
No, that I cannot change.
A fight between brother sister.
Yes, my lord.
Learned counsel for the respondent corporation seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 12 weeks. In the meantime, the order has been implemented, state.
It has been demolished.
No, my lord, it was demolished.
Demolished and again
On
restored.
the same day, the learned.
No need to say anything on that order. 12 weeks. You want to file your reply?
My lord, no, I have to file opposition, my lord.
That's what I'm saying. You want to file your opposition? Learned counsel for the
Respondent number
respondent as well as the private respondent number 4 seeks and is granted 4 weeks time to file, 2 weeks reply, 12 weeks.
Perhaps this is the
After November. Date मत दो इसमें.
this is the best order.
After 12 weeks. No date.
It will be ready for hearing after.
After 12 weeks.
Obliging. No. Thank you.
Can't help it, Mr. Nag.
Milord.
Can't help it.
You know, last occasion also I submitted. It's a absolute infighting. They invited us. They invited us. Milord. Obliging.
Well,
that matter. Anyway, on the last day,
No one appears. Last time also no one appeared. Today also.
I know, on the last day, I was not having a copy. Today I am having a copy. That Casey Nina is so fat.
Oh.
On last day, I was not having an extra
Tama-
copy. And with that other matter, your lordship would keep this judgment also. Hey, car pen রেখে গেল। 143, 146.
And after this is that the division bench which you.
Yes, after that, the division bench. And against that division bench, I had a word with Mr. Probal Mukherjee. He says that his client tried his luck before the Honorable Supreme Court only to be dismissed. The SLP was dismissed. Anyway, I leave it to your lordship, but these two judgments, your lordship would keep it.
I'll keep. Yes.
My lord, I beg to appear on behalf of the respondent bank, respondent number 4. I have no submissions. I am adopting the submissions made by my learned senior friend. No other submissions to make.
Take down. There was no appearance on behalf of the petitioner on 9/7/2025 as well as on 7/7/2025. Today also none appears for the petitioner, full stop. It seems the petitioner is not interested in pursuing the present writ petition. Full stop. The same is dismissed for non-prosecution.
I thought I will get a judgment from your lordship.
Yes.
No, I'll try. Then I'll in casuals, I will do this.
My lord, I have given my name in the box, my lord. It may be recorded, my lord.
Yes, yes. Your name in the box is recorded. Shamit Sanya.
I'm grateful, my lord.
For the bank, Shamit Sanya. No?
Item number 17, Mr. Tanmay Mukherjee is appearing on behalf of the petitioner, my lord. Mr. Mukherjee is stuck on question number 6, my lord. I'm praying for short passover, my lord.
Passover, not.
Matter is going, my lord, on 5 minutes.
Last time also you were not here. Read the order sheet. Where were you? Proxy counsel so and so appears and states that the main arguing counsel, Mr.
Mr. Tanmay Mukherjee.
Mr. So and so is busy in another court. Let this matter be listed. When do you want, Mr.?
But as your lordship, I have no.
Tomorrow?
Tomorrow.
Wednesday? Wednesday.
Yes, 18, my lord, I beg to appear on behalf of the rich petitioner. Lord, at the outset, I must be candid, my lord, due to judicial precedents laid down by your lordship, it appears to be an almost lost battle, but I believe it is worth, my lord, making an endeavor before your lordship. My lord, here, my lord, the subject matters of challenge, my lord, are, my lord, demand notices and, my lord, letter of intimations issued by KMC. My lord, initially claiming an amount of 16,93,000 and thereafter, my lord, an enhanced amount of 19,13,000 on account of outstanding property tax commencing from 2006 to 2024. Now, my lord, I am also aggrieved by, my lord, the notice of attachment of rent which has been issued to my tenant. My lord, the petitioner...
Your tenant?
No. I am, my lord, a lessee in respect of a commercial space. Now, my lord, the lease was executed on 17th of December 2019. And, my lord, the lessor indemnified me against past dues. Now, my lord, prior to execution of the lease, my lord, I inquired about pending property tax dues, my lord. My lord, I was intimated that an amount of approximately 1,40,000 was due as on such date. Thereafter, my lord, in March 2022, my lord, an amount of 4,87,000 was claimed. Lordship may kindly takes the trouble to look into page 76, my lord. Thereafter, my lord, this is, my lord, claiming page 76 is, my lord, a demand notice claiming an amount of 4,87,000 and all. Thereafter, my lord, another letter of intimation was issued. This was issued on 31st of January 2023. My lord, claiming an amount of 6,76,000. My lord, I liquidated these dues. Next page, my lord, is, my lord, the demand draft. And, my lord, page 78, my lord, is the receipt issued by KMC. My lord, till such date, my lord, page 78, my lord, is the receipt, my lord, issued by KMC. On 20th of, at the bottom of the page, your lordship will find the date has been recorded as 20th of February 2023. So, my lord, till such time, my lord, they did not intimate me, my lord, that there is allegedly an outstanding amount, my lord, commencing from 2006. Now in December 2024, my lord, page 84, oh, right. Page, my lord, 79, my lord, this notice of demand was issued to me.
79 or 84?
79, my lord.
On the top.
My lord, the previous amount they received without raising any demur, any objection. 19 লাখের নোটিশটা কোথায়? In January 2025, my lord, another notice was issued claiming, my lord, an amount of 19 lakhs, which is appearing at page 85. And they have, my lord, thereafter also issued during the pendency of this writ petition, my lord, after filing the writ
Page
petition.
85 is that 19 lakhs 13,316.
Yes. And ডেটটা কোথায়? কবে থেকে কবে চাইছে? And page 80, if your lordship may kindly take the trouble to look into once, my lord, your lordship will find, my lord, that these alleged dues pertains to the period of third quarter of 2006 till, my lord, first quarter of 2024.
First quarter of 20, fourth quarter of 22.
No, my lord, first, second, third, fourth column, my lord, second last row. Fourth column, second last row. Under the heading 2 quarter.
Yes.
First quarter of 2024. Thereafter, my lord, they have also issued, my lord, a notice for attachment of rent, my lord, which has been issued, my lord, to my tenant, my lord, directing him to pay the rent directly to the corporation. My lord, pursuant to my advice, he is complying with such direction. For the last 4-5 months, my lord, the rent is being directly paid to KMs. Now, my lord, there are basically, my lord, 3 issues which I am trying to canvass before your lordship, my lord. That is, my lord, in January 2023, my lord, they raised the demand of rupees, my lord, 6,76,895, which was, my lord, duly liquidated by me. They accepted the payment, my lord, without raising any demur. So now, my lord, perhaps subject to correction made by your lordship, my lord, they are now precluded or, my lord, stopped from, my lord, raising any demand pertaining to any period, my lord, prior thereto. বইটাতে KMC Act. Now, my lord, so far as interpretation of section 573 is concerned, my lord, I find very recently also your lordship has dealt with that provision, my lord. My learned senior colleague appeared in that matter, my lord. Lordship may kindly, my lord, for my satisfaction, once again, my lord, takes the trouble to look into section 573 of the Kolkata Municipal Corporation. My lord, I am aware of the 1998 judgment, my lord, presided over by my lord Justice Sinha, my lord, SB Sinha.
Which says there is no limitation.
Almost lost. এটা শাহজাহানটা বাদ। Section 573, my lord.
ওর কাগজটা যেটা এনওসি এর কথা বলছি। এনওসি ওকে দেওয়া হচ্ছে।
The lordship has found it. May I hand over my book, man?
কি বই দেবো?
What? 573?
Yes, of the KMC Act, my lord. Kolkata Municipal Corporation Act.
ये पुराना है ना, ये नया होगा।
1998 এ জাজমেন্টটা এনেছে বার কর। একটা জায়গায় বার কর লেখা আছে যে this does not apply only because this is appearing under a different chapter.
573.
573. My lord, may I only read this one? My lord, recovery of certain dues of corporation, save as otherwise provided in this act or the rules or regulations made thereunder, any sum due to the corporation on account of any charge, cost, expense, fee, rate, or rent, or any other accounts under this act, or the rules or the regulations made thereunder shall be recoverable from a person from whom such sum is due as if it were a property tax. Now, my lord, comes the proviso, which contemplates provided that no proceeding for recovery of any such sum, my lord, under this section shall be commenced after the lapse of 3 years from the date on which such sum becomes due. Now, my lord, it has been, my lord, judicially laid down, my lord, but that limitation, this limitation per se do not apply to, my lord, recovery of property tax. Now, my lord, what I am humbly trying to, my lord, submit before your lordship, my lord, is that this is a statutory power, my lord. First, my lord, the power to levy tax, which is one aspect, and then, my lord, the power to recover tax, which is a different aspect. Insofar as, my lord, recovery of tax is concerned or recovery action is concerned, my lord, all the imposts or all the dues which are my lord, the KMC is entitled to recover have, my lord, been put on the same pedestal, my lord, under this section. Now, my lord, the only reasoning, my lord, subject, with greatest of humility, my lord, that I find in the 1998 judgment, my lord, while, my lord, laying down that this limitation does not apply to recovery of property tax, is that this is appearing under a different chapter altogether. This, my lord, in my humble submission, is the only logic, my lord. My lord, had it been the intention of the legislature that this will not apply apropos, my lord, recovery of property, recovery of tax, my lord, this is appearing admittedly under a different chapter. This will then, in that event, this will not apply to any of the dues recoverable by the corporation. And recovery of tax, my lord, is a separate issue. The nature of different, there may be, my lord, difference in nature of dues. And all the judgments, my lord, your lordship will find, my lord, were passed in the context of, my lord, mainly a revision of assessment. My lord, here I am independently assailing only the recovery action.
You are a lessee.
I am a lessee. I am a lessee. I am in possession, my lord, by dint of the lease agreement, my lord, till 2075. So it is actually me, my lord, who is suffering.
This is between go and recover the money from the landlord.
That option that, my lord, I have, obviously. What I am most humbly trying to impress upon your lordship, my lord.
Why should I?
There must be some fetter, my lord. This cannot be, my lord, statutory power, my lord, cannot be exercised in, my lord, an unfettered or unbridled manner.
Why should this court interfere between a lesser and a lessee where your rights are governed by the terms of the lease?
Yes, my lord, but so far as payment of the dues are concerned, my lord, these are governed under the statute.
Recover from him.
My lord, I understand. My lord, the question I am
You
trying
think
to
it is
pose,
not right? Go and recover.
My lord, the issue, my lord,
What right do you have?
I understand, my lord. My lord, the issue I am most humbly, my lord.
For the lesser, I can understand. You are before this court, challenging the notice and other proceedings.
My lord, your lordship.
Whatever right you have, you go and recover from him.
My lord, I know that will be a
Or don't pay.
litigation, my lord. My lord, in the event that is not paid, my lord, penal actions will be
Very
initiated,
good.
distress sale, and
Leave the property, go somewhere else.
my lord, my lord, I am using, my lord, commercially exploiting this property, my lord.
Commercially exploiting,
my lord,
not exploiting, either pay or go.
I understand, my lord. But whether, my lord, the corporation, my lord, can, my lord, initiate a recovery action after, my lord, a reasonable period of time. My lord, your lordship is also aware of the Shahujahan judgment. Shahujahan Tabarko. My lord, the principle of reasonableness must be read into, my lord, this statute, my lord. Lordship kindly looks into, my lord, paragraph 18 and 23 once of the Shahujahan. I believe your lordship has on umpteen occasions already, my lord. Shahujahan Tabarko. 2018 বইটা আছে তারপর 328 only 2 paragraphs, মানে হ্যাঁ 18-3 328
CHN.
সরি 13 আর 28 My lord, only two paragraphs, my lord, 18 and 23.
ওর থেকে আমি নিয়ে নেব না তুই কর পড়ে নে তারপরে
My lord,
আমি
17, my lord,
I'm called
section
for
573 has been reproduced
আর হন না
at page, my lord, 38334. Not 3834. 33. নয় আরেকটা বার কর।
Yes.
Now, my lord, the 1998 judgment, my lord, of Abdul Ghazi, my lord, it was, my lord, which says that, my lord, this limitation prescribed under section 573 is not per se applicable, apropos, my lord, recovery of property tax, my lord. It was, my lord, delivered by a division bench of this honorable court, presided over by my lord Justice Sinha, my lord Justice Sinha, my lord, in Supreme Court, my lord, is, my lord, explained the word, my lord, reasonable. If I cannot satisfy your lordship, my lord, that this limitation is applicable to, my lord, recovery action of property tax, my lord, my submission would be that some reasonable time should be exercised within some reasonable time. Now, my lord, principle of reasonableness and reasonable time, my lord, his lordship was pleased to express, my lord, explain. Lordship may kindly looks into it once, my lord, although in a different context altogether, in the context of specific performance.
কোনটা বলছি
Paragraph 29.
এটা কোনটা
2009.
Specific performance scenario is different altogether.
কত
I have indicated.
SCC 27 তো শাহু জৈন যখন হয়েছে তখন আব্দুল গজনবী has not been considered. So I have showed it to the court.
Lordship may, acha copy actually nahi dada diye dichi. Lordship may kindly takes the trouble to come to Placitum, my lord, F. Paragraph 29. A previous judgment of, my lord, Viraya Amal has been quoted. Thereafter, my lord, paragraph 13 of Viraya Amal, my lord,
Yes, read out. What do you want to read?
yes, my lord, Placitum F, my lord. Placitum E. It was furthermore observed, Variamal, paragraph 13, the word reasonable has in law prima facie meaning of reasonable in regard to those circumstances of which the person concerned is called upon to act reasonably, knows or ought to know as to what was reasonable. It may be unreasonable to give an exact definition of the word reasonable. The reason varies in its conclusion according to idiosyncrasy of the individual and the time and circumstances in which he thinks. The dictionary meaning of reasonable time is to be so much time as is necessary under the circumstances to do conveniently what the contract or duty requires should be done in a particular case. My lord, my submission is if no fetter is put, my lord, judicially apropos this power, my lord, this will lead to a catastrophic, my lord, situation where, my lord, corporation can very well come up with a demand which is 30-40 years, my lord, long. There will be no end to it, my lord. A reasonable time, my lord, looking at all the circumstances of the case, a reasonable time under ordinary circumstances, as soon as circumstances will permit, so much time as is necessary under the circumstances convenient to do what the contract required should be done. Some more protracted space than directly, such length of time as may fairly and properly and reasonably be allowed or required, having regard to the nature of the act or duty and to the attending circumstances. So, my lord, they had a
Come back after lunch. After lunch, Mr.
Just now.
Since your lordship has given me, my lord, so much indulgence, only one more judgment, my lord. This is, my lord, in the context of exercise of statutory power, my lord. In the
Take
event
your
that-
time. I'm not cutting you short. I'm not cutting you short. Take your time.
My lord, this pertain to, my lord, acquisition of land, my lord, and declaration of ceiling under the Urban Land Ceiling Act, my lord. There was
My
no-
only question, which is that how are you aggrieved?
My lord, ultimately, my lord, it is the rich petitioner, my lord, who
The
is
li-
paying. Because I have tried to, my lord, make contact with the, my lord, lessors, my lord.
Then what happened?
I have implemented them in the writ petition.
Then-
Copy has been served, my lord. They are not appearing.
Claim has also been made from the persons who have assigned him the lease.
Claim has been made by him.
Yes, the letter is there, very much clear. Even in the
After-
petition, there is a pleading. Anyway, let my
Pursuant to my request, the KMC, my lord, has bifurcated the dues. One prior to 2019, December 2019, and my lord, the dues, my lord, which arose thereafter. My lord, I have requested them to pay the money, the previous dues, my lord, they did not respond. My lord, I have implemented them in the writ petition. They are not appearing. My lord, it is my tenant, my lord, who is directly paying the rent to the corporation. My lord, this rent, my lord, I had been utilizing for the purpose of, my lord, giving the, my lord, EMIs pertaining to the, my lord, credit facility that I had availed, my lord. So it is ultimately the writ petitioner who is being prejudiced.
Yes.
And my lord, so far as, my lord, in the event no limitation has been prescribed, my lord, apropos exercise of, my lord, statutory power, my lord, it has been held, my lord, in catena of judgments that it must be exercised within a reasonable time. Now, my lord, 2010 8 SCC, my lord, 467. My lord, may I hand over only two paragraphs, my lord? 8, sir, 467. This is in respect of exercise of revisional power under the Urban Land Ceiling Act 1976. Paragraph 26, your lordship will find, my lord, at page 474, the last paragraph. Lordship may kindly turns to the next page. My lord, paragraph 11 of, my lord, State of Gujarat versus Patil Raghav judgment was quoted. This power must be exercised in reasonable time, and the length of the reasonable time must be determined by the facts of the case and the nature of the order which is being revised. Thereafter, my lord, paragraph 28. My lord, this is in the event your lordship is not satisfied that the proviso to, my lord, section 573 is applicable apropos demand of property tax. My lord, may I read, my lord, paragraph 28? The legislature in its wisdom did not fix a time limit for exercising the revisional power, nor inserted the words at any time in section 34 of the 1976 Act. It does not mean that the legislature intended to leave the orders passed under the Act open to variation for an indefinite period, inasmuch as it would have the effect of rendering title of the holders' allottees permanently precarious and in a state of perpetual uncertainty. In case it is assumed that the legislature has conferred an everlasting and interminable power in point of time, the title over the declared surplus land in the hand of the state allottee would forever remain virtually insecure. The court has to construe the statutory provision in a way which makes the provisions workable, advancing the purpose and object of enactment of the statute. My lord, what I am humbly trying to submit before your lordship, that this power, my lord, to recover tax, my lord, levy of tax, my lord, I have already indicated is a separate aspect. And my lord, power to recover is a different aspect. In my humble submission, number one, my lord, in 573, all the dues recoverable by KMC, my lord, have been placed on the same pedestal, particularly due to insertion of two expressions, any sum due, and my lord, any other account. This is, my lord, by operation of the principle of adjustum generis, the component of property tax has also to be, my lord, included in my humble submission. And second is, my lord, if this is not applicable, if this is your lordship's view, my lord, that this limitation is not applicable, then, my lord, it must be exercised within a reasonable period of time, which, my lord, cannot, my lord, they cannot be allowed to, my lord, exercise it in an arbitrary manner. And third, my lord, is that the first one, my lord, is that after accepting the dues, now they are, for the subsequent period, now they are precluded or stopped, my lord, from claiming any previous dues. Number two, this limitation. And number three, my lord, it is ultimately the lesser who is, my lord, liable to pay money, at least prior to December 2019. These are my submissions.
Yes.
Look, this is the property at Park Street. After, my lord, getting an assignment of the lease, the petitioner never bothered to get his name mutated in the property. The property still name stands in the name of Subha Jain. That is, the persons who had assigned the leasehold interest unto my learned friend's client. Now, my lord, after taking the property, taking into possession,
Yes.
he has rented it out. That is admitted.
Oh.
The particulars are not there, but he has rented it out. Now, that rental basis became the basis of determination of valuation. Now, whatever notices were given, that landed up with Subha Jain. My learned friend today cannot argue that, well, I did not have any notice. I did not know anything. If you do not know anything and if you do not have the notice, it is created by you by not applying for mutation, which is provided under the Act. That is one aspect of the matter. Thereafter, my learned friend goes in.
He would have not got the mutation.
On that, at that point of time, the dues had it been paid because it came in 2019.
Still, he remains a lessee only.
No, he would have been person liable. The main name would have been there, but the person liable would have been him. It would have been, if your lordship kindly
It will not be. It will not be mutation. He can be an assessee in terms of the lease.
Yes, so his name would have come and he would have immediate. If your lordship takes page 75, I'll just explain what would have happened. Page 75, your lordship sees?
Yes.
On the top, name is Subha Jain and Vikas Jain.
Yes.
They are the one from whom he has taken. Now, this would have been there because, and here, after the address, it would have come this Fajol Bhadra, person liable. So, if that is there, then he would have got all the notices. Now, taking a cue from my learned friend's argument, he has firstly shown Shahu Jain. একটুখানি দিবি বাবু Shahu Jainটা? Shahu Jain. My lord has got a copy. আচ্ছা তোর কাছে কপি আছে তো? আরে দেখ আমি তুই আমাকে বলছিস
Saul Jain.
His lordship he has handed up the book.
Yes.
CHL, yes. That is, your lordship would
What is the
kindly
page?
come to
Page number?
page 328.
No, but Mr. Mukherjee, you're not. Is this even maintainable? Is it maintainable?
No, I'll just explain just in 2 minutes.
Yes.
My lord knows it better than me. First is identification of an object which is to be taxed.
Correct.
Then comes the levy. then comes the assessment, then comes the recovery, whatever the tax assessed. Now, if your lordship kindly comes to Kolkata Municipal Corporation Act, it starts from, the chapter starts from section 170. Taxation. Chapter 12. Now, this is a complete code and it ends up with section 232B. And in between, your lordship would find, after the taxes are levied and assessed, now the recovery starts from section 214. Section 214 starts with the recovery. 14, 15, if your lordship just peruses, these are all related to recovery. Presentation of bill, notice of demand, 217. Then, my lord, then 218, and if he fails thereafter, then comes all these provisions. Recover 219, recovery of tax, distress, disposal of distrained property, attachment of sale and immovable property, sale of property distrained. So this chapter, this part 4, is a code in itself which identifies the object, provides the procedure for assessment, then it also provides for the recovery part. Now, what happened in Shahu Jain? If your lordship kindly takes paragraph 1 and paragraph 11, I'll just read it out. In 2004, the writ petitioner filed a writ application challenging the vires of the second proviso to section 179(2)(d) of KMC Act. So what was under challenge? My lord has got first 3 lines. So 179(2)(d) vires was challenged. This provision said that the municipal commissioner can at any point of time, even if the pending GRs, general revaluation, which are pending, the municipal commissioner can take up these GRs at any point of time. My lord would kindly note, at any point of time. Now, in this case, 5 such GRs, general revaluation, which happens after every 6 years, fell due. Where from your lordship would get it? Your lordship would get it from paragraph 11. In the instant writ petition, the appellant writ petitioners have sought a declaration that the second proviso of the Kolkata Municipal Corporation Act is ultra vires Article 14 of the Constitution of India. Further, the assessment orders dated 16 November 99 for the assessment period, my lord would mark the periods 84-85. Just 6 years thereafter is 1991. Then there is one inter. Thereafter, again general revaluation, 96-97. Then there is one inter. Then the other one is an inter. Now, all these valuations were taken up in one go. In that backdrop, the Honorable Court, my lord, the limitation, my learned friend was just placing section 573. It provides a limitation of 3 years.
Yes.
Now, that 3 years period was incorporated in 179(d), and the court did not declare 179(2)(d) to be ultra vires, but it read down, saying that I can only go back for 3 years, but it is assessment. It has got 179(2)(d) also, if your lordship sees, it has got nothing to do with the recovery. It deals with the assessment part of the building. Now, what does 573 say and the interpretation ওটা দে আমাকে বইটা দে while delivering judgment in Shahu Jain case, my lord, I most with very humbly I submit the honorable court did not take into consideration one judgment which is AIR 1998 Calcutta 345. My lord, it is already in a very brittle condition. I'll just read and hand it up. Now,
This is AIR? AIR?
AIR 1998, page 345. It's a bench presided over my lord Justice S.B. Sinha. My lord, I read it. My lord, there is one paragraph which is very long, that is paragraph 4. I'm reading from that. There is no doubt there exists no provision for limitation so far as the recovery proceedings are concerned. Under Kolkata Municipal Corporation Act, there is no limitation for recovery. Assessment, the court has interpreted it 3 years. But recovery, there is none. Mr. Banerjee, however, has relied upon section 573 of the Act, which provides for recovery of certain dues and reads thus. 573 has been quoted. Recovery of certain dues of corporation, save as otherwise provided in this Act or the rules or the regulations made thereunder, any sum due to the corporation on account of any charge, cost, expense, fee, rate, or rent, or any other account under this Act or the rules or regulations made thereunder shall be recoverable from the person from whom such sum is due, as if it were a consolidated rate, provided that no proceedings for recovery of any such sum under this section shall be commenced after a lapse of 3 years from the date on which such sum becomes due. Here, why my learned friend wants to park himself. Section 573 occurs in Part 3, Chapter 14, which deals with the power, procedure, offences, and penalties. Section 573, on a plain reading, cannot have any application as regard payment of recovery of tax, interest, or penalty provided for in Chapter 14 of the Act. It is now well settled, the principle of law, that a due of a person reliable from another does not efface, or the claim of such person stands extinguished even in a case where limitation applies. In terms of the provisions of the Limitation Act, recovery of a sum by taking recourse to filing a suit becomes barred. Limitations Act 63 cannot have any application in relation to recovery of public dues unless the statutory provision exists therefore. Then thereafter, my lord, I do not want to trouble your lordship. A special statute may provide for limitation or may not. In the instant case, the proviso appended to section 573 of the Act only provides for limitation. Section 573 cannot have any application in relation to the taxes, inasmuch as by reason thereof a legal fiction has been created. By creating a legal fiction, a putative or imaginary state of affairs is treated to be real state of affairs, although it is not. The wordings of the provision, particularly the words employed in a provision of restrictive statute, should be construed in such a manner so as to enable the court to give full effect thereto. The proviso appended to section 573 which makes out an exception, provides for a limitation as regards the recovery of impost stated therein, which has to be recovered by as a consolidated rate, meaning thereby such recoveries inter alia could be made in terms of provision of section 220. But if any limitation for recovery of any taxes was to be provided for, the same should have been done by using a clear and unequivocal language by the legislature in chapter 14 itself. Recovery of tax is also an incidence of tax. It is now well known that there cannot be any intendment so far as the imposition of tax is concerned, and in that view of the matter, there cannot be any intendment so far as the recovery of tax is concerned, nor any presumption can be raised that upon expiry of certain period, such taxes cannot be recovered. A provision for limitation can only be brought about by a statute. Such statute in certain cases may be the statute of repose, but the legislature in its wisdom may not make any provision therefore. So, my lord, what my learned friend is submitting goes against the tenets of this judgment. Hey, your lordship sees this paragraph is very longish paragraph. Paragraph 4, which your lordship will see starts at page 346. Now, if your lordship turns over to page 349, then on the right hand side, 1, 2, 3, 4, 5th paragraph, there is no doubt. My lord has got those words. There is no doubt.
Read it.
349. Should I read it once more?
Yes.
There is no doubt that there exists no provision for limitation so far as recovery proceedings are concerned. My lord has got it at page 349, right hand side, 5th paragraph from the top. There is no doubt. My lord has got that.
The entire judgment is
My lord,
not
the
coming.
entire judgment, paragraph 4 is very longish.
That's
And
it.
one has to read it between the lines. Now, my lord, so the argument, what my learned friend had forwarded goes against the tenets of this judgment. This is directly on the point whether a limitation can be imposed upon recovery of tax. Here we are on the recovery of tax.
But do we need to go into this? Do we actually need to go into this?
Because he having not been got into mutated,
correct.
He doesn't have any locus to urge all these points.
That's
Doesn't have any locus to urge these points.
Correct.
My most respectful submission. Now, my lord would see his pleadings kindly at paragraph 6. I'll read it for your lordship. Instantaneously, upon being made aware of such outstanding amount of property tax, your petitioner had duly brought it to the notice of the respondent number 4 and 5, that is Sudha Jain, at page 5, para 6, who in turn assured and promised your petitioner regarding payment of such outstanding amount prior to execution of the deed of assignment and sublease. Now, paragraph 8, immediately subsequent to the transfer of the subject property in favor of the petitioner, due to outbreak of pandemic, steps could not be taken by your petitioner to deposit property tax commencing from 220. He admits he could not pay or he did not pay, whatever the reasons are. Then your lordship would also he says that I have put it on.
So paragraph 19 বলেছে upon being accepted.
That's clear. He says at paragraph 3,
Till date, the name of the respondent number 45 appears in the records of the respondent number 1 as persons primarily liable to pay property tax. Then next paragraph. Upon the transfer being complete, your petitioner has let out the subject property. Paragraph 4. So he says that they are liable, then he takes and puts it into rent. Now he takes up the issue with the landlord, with the superior landlords, that is the Sudha Jain and all. So today, and he has said, if I have heard my learned friend correctly, he has said that the corporation has already taken steps under section 225 and attached the rent. So nothing remains today of the lease. What he is trying to urge, nothing remains. My lord, it's my most respectful submission.
Yes, sir.
Only one document, my lord, I have sought to brought on record by way of a supplementary affidavit because this was issued.
Now at this stage,
No, I had indicated, my lord, attachment of rent, my lord. This was also, my lord, served on me, my lord.
No supplementary. This stage, what supplementary?
My lord, the notice of attachment of rent, my lord, it has also been, my lord, it records my name also.
Sir, you yourself are saying that in para 3, in para 4, in para
My lord,
6.
from January 2020 onwards, I am liable to pay property tax. My lord, I have already deposited 6 lakhs, my lord. Now they have already recovered, my lord, more than 5 lakhs, my lord, on account of attachment of rent.
Very good.
Out of 19. So 11, my lord, almost 11 has already been paid. My lord, my dispute is with regard to, my lord, the dues prior thereto.
Can
My
you
lord,
dispute to the civil
I
court?
do not want to, my lord, disown my liability commencing from 2020.
File a recovery suit against the.
Your lordship is aware, my lord, that will be a protracted litigation, my lord.
What to do? We can't cut short these litigation in writ petitions.
I completely understand, my lord.
Corporation as a tool for the purpose of recovery.
We can't do that.
No, that I cannot, my lord. I bow down to your lordship, my lord. My lord, I have already submitted whether, my lord, this power, my lord, should be exercised within the reasonable time or not.
Power, you are nobody to challenge the power, sir.
My lord, this, my lord, money, my lord, ultimately I am
right. Recover it from. You're not liable to leave the place. You're just a lessee, nothing else. Leave the place, and that too, you're earning money out of it. You have rented it out.
Yes,
This whole thing is only because of you, because the rental is so high that the taxes or liability may have gone up.
They have, my lord, claimed from 2006, my lord.
Anyway, whatever it is.
I have been inducted in the property in 2019 December, my lord.
Whatever you
Lord,
file
I do
your
not
petitions,
know whether
whatever
the
petitions
bills
you
were
have to-
presented or not.
Sir, today you are nobody. This court doesn't recognize you. You are nobody who can challenge it. A third person cannot challenge an assessment. You are a third person.
My lord, my rent, which I, what has been attached, my lord. That is what, my lord, I was trying to
That's
draw
the
your
reason why
lordship's
you should
kind
have got the
attention.
mutation done in your name. Maybe that would have helped you.
My lord, possibly, my lord, they will not, my lord, allow me to, my lord, mutate the property, my lord, unless the previous dues are paid.
That's the reason you have filed a writ petition.
No. That is not the reason, my lord. My lord, I have already paid, my lord, the previous dues. Immediately after the demands were made.
Take down. The petitioner, comma, by way of the present writ petition, comma, assails the legality and propriety of one demand notice dated 6/12/2024, full stop. Second, letter of intimation dated 13/12/2024, full stop. Third, notice dated 1/1/2024, issued by the respondent municipality in relation to the alleged arrears of property tax in respect of premises situated at 5B, comma, 5th floor, comma, 71, comma, Park Street, comma, Calcutta. Full stop. It is the specific case of the petitioner that he had entered into a registered deed of assignment and sublease dated 17/12/2019. Registered deed of assignment and sublease 17/12/2019. Primarily for commercial exploitation of the above mentioned property. Full stop. As per the mutual understanding, the terms of the said registered instrument, as per the terms of the said registered instrument, comma, it was clearly agreed between the parties, between the petitioner and respondent number 4 and 5, that all municipal levies and dues, including property tax called, comma, accruing prior to the deed of assignment, i.e. 17/12/2019, comma, would be the sole responsibility of respondent 4 and 5. The said respondents further undertook to indemnify the petitioner against any liability arising from non-payment of such prior dues. However, comma, on or about 14/3/2022, comma, the petitioner noticed that a demand of rupees 4,87,384 had been affixed on the wall of the said premises by the respondent municipality. Full stop. Upon making inquiries, the petitioner came to know that the letter of intimation was addressed by the municipality to respondent number 4 and 5, comma, whereby the outstanding amount was revised and shown to be 6,76,896. In a bona fide attempt to resolve the issue and to avoid any disruption in his commercial activity, comma, the petitioner made a payment of rupees 6 lakhs to the respondent on 22/2/2023. 3. Despite the aforesaid payment, comma, the petitioner was subsequently served by a notice dated 6/12/2024 under section 2171 of KMC Act, claiming a further amount of rupees 16 lakhs 98,185.91 towards outstanding property tax due. It is stated by the learned counsel for the petitioner that the amount of 6 lakhs was not adjusted towards the demand raised by the petitioner, by the respondent corporation. Full stop. Petitioner further submits that despite his repeated attempts to facilitate a tripartite meeting between the respondent municipality and the private respondent number 4 and 5, comma, for the purposes of arriving at a resolution and proper allocation of liability, comma, such meeting could not take place due to non-cooperation of the private respondents 4 and 5. Thereafter, petitioner received another communication dated 1/21/2025 demanding an enhanced amount of rupees 19,13,316 as arrears of property tax. The 19,316 page बता देता हूँ, page 85. The petitioner, aggrieved by the repeated and escalated demands, contends that he is liable to pay property tax only from the date of execution of the deed of assignment and sublease, i.e. dated 17/12/2019 onwards and 19 onwards and not for any period prior thereto. Full stop. The counsel for the petitioner submits that the demand raised for the period prior to entering of the lease deed and sublease, the sublease were in exclusive possession of, the property was in exclusive possession and control of respondent number 4 and 5, and they are liable to pay the property tax and had also undertaken such liabilities in the lease deed. Full stop. That's what the case is, right? The petitioner further states that despite making several representations and personal requests to the private respondent number 4 and 5. You have got the bifurcation now?
Yes,
Yes, we have done it.
Right. The petitioner further states that he has received the bifurcation of the property tax from the municipality, and from the same it is evident that the
84.
The petitioner is not liable to pay the entire property tax as demanded by the corporation in terms of the lease deed, as a deed of assignment and lease deed. Full stop. Learned counsel for the respondent municipality states that the petitioner has already been given the bifurcation of the outstanding property tax in respect of the above mentioned property. Full stop. He states that the present writ petition is not maintainable since the assessment has not been done qua the petitioner, but the assessment has been done qua the private respondent 4 and 5, who have not challenged the assessment orders passed by the respondent municipality. Full stop. This court is of the considered view that the understanding between the petitioner and respondent number 4 and 5, including the clause of indemnity or allocation of tax liability, constitutes a purely private arrangement between the said parties, and the respondent municipality cannot be bound by such internal agreements. From the standpoint of the municipality, its claim pertains to recovery of legitimate property dues against the premises in question, comma, irrespective of any internal disputes or arrangement between the past and the present occupier of the said property. Full stop. Accordingly, if the petitioner is aggrieved by the action or omission of respondent number 4 and 5 regarding payment of earlier dues or their failure to comply with the terms of indemnity, comma, the petitioner shall be at liberty to challenge. The petitioner shall be at liberty to initiate proceedings, appropriate civil proceedings for enforcement of such rights. Full stop. Such inter se disputes cannot be adjudicated in the present writ jurisdiction. The respondent municipality shall be at liberty to proceed for recovery of the outstanding dues in accordance with law, comma, subject to the petitioner's right to dispute or contest the liability on such basis as available to him in accordance with law before appropriate forum. With the aforesaid direction and observation, the present writ petition stands disposed of. Anything else? There's a limitation, there's a problem. I would have interfered, but I can't. You have a lease deed whereby you have an indemnity clause. You can very well claim all your damages prior to that.
I understand.
So to say that, assessment has been rightly done, wrongly done.
That is why, my lord, I have not assailed the assessment, my lord. I am only assailing, my lord, the recovery part.
The recovery is part of the assessment. See, like what Mr. Mukherjee rightly pointed out, these are stages.
There are stages.
First, second, third. The assessment has been done, the order has been done, and then distress notice or demand notice or whatever is. It's a subsequent proceeding of that.
My lord, may I take back the journal, my lord?
Yes, yes. Indemnity. Yes. Indemnity. Affidavit is taken out.
My lord, behalf of Kolkata Municipal Corporation, my lord.
इसको थोड़ा और वो कर दो. Next.
Lordship, I beg to appear for the petitioner. In this matter, Lordship, we have informed that the client do not proceed with the matter. We sought for written instruction. Kindly, Lordship, keep the matter next to it so that we.
Are you the lawyer on record?
Yes, Lordship.
Dismissed. Dismissed for non-prosecution. Learned counsel petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Clear appearance.
Uh, 20, my lord, I am for the petition.
My lord, I am for Kolkata Municipal Corporation, my lord.
But petition has been running a business of.
I am for the private respondent. I am praying for not today. I am led by Mr. Senior Advocate Mr. Vikash Bhattacharya.
But petitioner has been running a business of food and beverages, my lord.
Yes.
But
I'm praying for only not today.
has it?
Who are you appearing for?
I'm for the private contact number 789.
Ibrahim Biryani. Not today.
Deeply obliged, my lord.
And we saw an automatic last 25th of February.
I'm appearing in, I don't know, 21 minutes. This is my application, Malat. This is the second round of application, Malat. What has happened, Malat? The Howrah Ministry of Corporation, Malat, we put in a sanction plan, or rather, we put in a plan for a sanction, Malat, in the year 2020. Now, Malat, what happens? From 2020, Malat, I'm not being given the plan. Several rounds of litigation. Ultimately, Malat, Howrah Municipal Corporation passes a reasoned order pursuant to an order passed by Honorable Justice Sinha, where they say, Malat, that we are ready to give, but subject to a NOC to be procured on 17 grounds from the police commissioner, Kolkata. Now, Malat, this was absolutely beyond jurisdiction and without any reason. Now, on 25th of February, Malat, an order was passed by this court, Malat, where, Malat, the honorable judge found that, Malat, they were relying on that it is within a security zone of the place Nobanno, Malat. And that is why they were not giving us this sanction. But his lordship found that that security zone was only for 500 meters. And my Malat, property is beyond 1 kilometer. Right? Beyond 500.
It's beyond the notified area.
Beyond the notified area. So therefore, Malat, this order was passed, asking the Commissioner of Police to file a report as to how the restrictions could be imposed in rest of the proposed building which is outside the security zone. And Malat, today we have not received anything.
Long time, 3 months.
It's nearly more than 5
I
months.
appear for the petitioner in the other matter, my lord. I am at the mercy of everyone, my lord. I am languishing. My lord, my building has been, my lord, raised to the ground, my lord. Now they are not.
There is only one restriction that could be imposed.
Malat, kindly see the security zone, Malat, the imposition, they have referred themselves, Malat, to a notification. Malat, if your lordship kindly see the notification, which, Malat, is at page 186. Kindly see the notification, Malat.
Yes.
So, Malat, kindly sees, whereas the government of West Bengal in the home and such, for the purpose of security and safety of the land and building and areas, deems it necessary to declare, Malat, shall be subject to the control of the Commissioner of Police, Kolkata. Now, kindly see, and whereas the government of West Bengal department further deems it necessary to prohibit and or restrict the sanction of any building plan, now see, Malat, exceeding 15.5 meters of height from the ground level within 500 meters radius of the said area, for the purpose of safety and security of the said area. Now, therefore, in exercise of the powers, Malat, that the area has been designated, Malat, kindly see serial number 1. It's only the HRBC building.
Nothing else.
Nothing else. HRBC building, multi-level car parking outside the north gate and other areas inside the boundary wall
Of
HRBC. So they have designated Nobanno and whatever is in between and within the boundary wall as a security zone.
Here I am not raising construction.
Now, Malat, we are not raising constructions there. Now, Malat, kindly sees when this honorable court was pleased to.
Zone is this area.
I'm sorry.
Security zone is the area which has been defined, which is your.
It's within the building. HRBC building within the boundary wall.
It is the. So that is the entire radius of the area which has been declared to be the security, right?
Yes.
And beyond that 500 meters. No.
Wait.
That's not.
Malat, beyond that 500 meters, what has been mentioned, Malat,
Yes.
There are two things, my lord. One is,
Sir, have you seen, if you draw analogy with ASI Act, any prohibited area, what is a prohibited area? The area which is designated as prohibited and any construction beyond 100 meters, 200, same analogy for airport, same analogy for many other.
that I am not falling within that.
So, no, where is your property?
I mean, that is what I'm saying. I am beyond 500 meters, one. Second is, my lord, the only prohibition is the building should not be 15.5 meters in height.
Yes.
My lord, that is why I was taking your lordship. My lord, kindly comes to the reasoned order passed by the corporation, pursuant to orders passed by this honorable court, my lord. That is what I wanted to show your lordship.
Yes.
That the only restriction, I'm taking their best case that I'm within that area. The only restriction is, my lord, that I am my lord, that I am within 500 meters. My lord, first, my lord, kindly sees. My lord, kindly comes to page 89. No, first 88. 88, man. I'm sorry, man. The petitioner's contention, just in the middle paragraph, man.
Just
Sorry.
Wait, just one second. Page 88, yes. Page 88.
88 onwards, my lord.
Yes. There's some problem with the pagination or?
Malad has taken up 2445, Malad. I'm sorry, Malad. There are two writ petitions together.
Yes.
2445, Malad. আমি তো 2445 আমি এই যে পেজ ফার্স্টে আমাদের সাবমিশন
25157 is another writ petition.
Yes.
The other one.
বলবো oh I'm sorry Malad. I got the wrong page number Malad. I'm sorry.
Yes.
I'm sorry Malad. There are several, so I got the wrong page number. Malad kindly takes page 172.
That's
174. Malad, the middle paragraph, petitioner number 2, represented by the learned advocate, submitted. Now, Malad, at the bottom of that paragraph, your lordship will kindly see, fees in that regard have been calculated for G plus 4 story, height 15.49 meters. So, my lord, I'm within, that is my submission. Now, my lord, kindly comes straight to, my lord, page 178. My lord, the second paragraph there. This is the finding of the Howrah Municipal Corporation. In the instant matter, the height of the proposed building is about 15.49 meters admittedly. That's my lord. And the representative of the police and security department have not denied the same at the time of hearing. Before the undersigned does not cross the height limit mandated for Nobanno security zone dated 12/9/2019. And is, as such, the HMC cannot refuse the sanction plan of the building on that ground. So, my lord, if your lordship kindly now takes, my lord, the provision of law, my lord. If I can show that to your lordship, my lord, once. My lord, kindly takes Howrah Municipal Corporation Act, my lord, section 243. My lord has got them.
Thanks to Mr. Banerjee.
243, my lord. Next.
Yes. Security zone and government land and building.
What is the maximum they can, my lord? That is what I'm trying to show. My lord, 243, security zone around government land and building.
Notwithstanding anything contained in the state government in the home and hill affairs for the purpose of security and safety of the strategic installation on land and building belonging to the government or semi-government agency or institutions within specified area or areas of the corporation may notify that area or areas as security zone, and that shall be subject to the control of the Commissioner of Police of the concerned areas, provided that this section shall in no way derogate from the powers vested in the corporation or any other municipal authority of this act, enabling the corporation of such authority as the case may be in the interest of public health to require the owner or occupier of any land or building in such area to remedy or abate any sanitary defect or in such land. That is not necessary. Next, my lord, can be seen sanction of state erection of masonry building. Notwithstanding anything contained in the foregoing provisions of this chapter or any other law for the time being in force, the state government may, if it deems and if it necessary, prohibit or restrict the case may be, now kindly see, sanction of building exceeding 15.5 meters.
That's the only
Now, my lord, very quickly, my lord, I'll take your lordships to one more. That is the last one, my lord. Section 246. Notwithstanding anything contained in section 244. So, my lord, notwithstanding anything 15.5 meters. Permission to erect a masonry building in such area or areas of the corporation as declared security zone under section 243 shall not be given so as to contravene by rendering less strict any of the provisions of this act regulating the construction of building, and the provisions of section 245 shall be in addition. So the corporation can give me whatever they are entitled to give me or put upon me as condition for a sanction, and this will be not in derogation but in addition. So, my lord, the ultimate power of giving the sanction lies with the corporation authorities. Now, what does the police have a right? The police right is only restricted to the security zone, and the security zone will only give them the height restriction. Now, my lord, kindly sees the reasoned order once more, my lord. Where I was, my lord, I have shown your lordship 178. In the, well, just after that, what I read, last paragraph 178. In the said circumstances, the HMC will take up the sanction process of building with proper execution of 17 points, terms and conditions laid by Kolkata Police Directorate to the MB, that's me, my lord. After getting necessary approval, the MB has to follow the guidelines strictly as stated in the NOC issued by the Kolkata Police Directorate. And my lord, kindly sees the conditions, 17 conditions. It's just one after another.
No, but this is not under challenge before me.
Sorry, my lord?
Yes, this is under challenge. No, but then this is a judgment by the single judge.
My lord, no, this is a reasoned order of the Howrah Municipal Corporation, my lord.
The Howrah Municipal Corporation in pursuant.
Howrah, my lord, pursuant to an order passed by this court, a reasoned order was passed. On this reasoned order, my lord, we have challenged that, saying that you cannot impose such conditions. Because, my lord, it is the law, as far as I understand, my lord, that
it has been passed after giving hearing to the police, along with them.
The Howrah Municipal Corporation under the Corporation Act has not found anything which can prevent me from getting the sanction plan.
Show the restrictions.
Now see the restrictions.
What is your problem?
Well, these
On the
restrictions.
17, what is a, let us crash it out. You want
Let us, my lord. Could not be used for any kind of commercial activities.
how can you put this clause?
And the police, the state.
How can the police put this?
We are not agreeing to commercial activity.
Where does the police get the power? You appear, Mr.
Actually, my lord, I was led by Mr. Kullan Bandyopadhyay in this matter, my lord. He will argue before his lordship because it's a very sensitive issue. Lordship, kindly appreciate, my lord, the Navanno is, my lord, is the state headquarter where all the chief minister and all other everyone is sitting. Now, my lord, the things is that, my lord, if we allow anyone to raise construction in Navanno area, my lord, that is the whole crux in this matter. So that's what Mr. Bandyopadhyay will argue. in
If
this.
parliament is there, then in and around parliament, there can't be any
No,
development.
Similarly,
Or if the
certain
prime
restrictions-
minister sits
certain
in,
restrictions are there, my lord. Certain restrictions are there, my lord.
Kindly look into the restrictions.
show the restrictions, sir.
In lordship, in the
Where is
last.
you were supposed
lord.
to file a report, right? Where is the report?
No, but I will file a detailed affidavit, my lord, in this. It's better, my lord, to file an
These are
affidavit.
delaying tactics.
There is a direction of this
No, my
court
lord,
on
kindly
February.
cease prayer, my lord. If
There is
there is only one prayer, my lord.
Wait a minute.
And my lord, in the last
To
page,
violate
my lord,
ordinance.
lordship will find page 186, there is a notification. Kindly takes page 186.
I've shown that. That is the notification I was talking
No,
about.
no, kindly takes page
Security
186.
zone.
Mr. Malik, please have a look at the order of 25th of February. The order itself records, let the Commissioner of Police file a report as to show the restrictions could be imposed in respect of the proposed bill.
I will file a report, my lord. If lordship grant me a short time, my lord, I will file a
It was
report.
already granted to
No,
you
my lord,
in
kindly, my lord.
February.
Now, my lord, I just showed to his lordship just one line, my lord, page 186. Page 186 kindly takes once.
Page 186.
Lordship kindly takes page 186 once.
Yes,
My lord, now kindly see first, second, third paragraph.
yes.
Now, therefore, in exercise of the power conferred so Howrah Municipal Corporation, as subsequently amended, the governor is pleased to hereby declare, with effect from the date of publication of the notification of the official gazette, that the area as specified in the schedule below shall be treated as security zone and prohibits the sanction of building plan exceeding 15.5 meters of being from the ground level within 500-meter radius of the security zone. They have come within 100-meter radius. They have come within 100-meter radius. Well, how we will allow?
That is not the stand of the corporation, sir. Mr. Banerjee,
That's what I am saying.
where is the property?
And 100 meters. Sorry.
Corporation will abide by guidelines by the.
Mr. Banerjee, please don't make a mockery of this court.
Only the high.
Sanctioning authority, you are the sanctioning authority. Where is the property situated? The statement made, wait a minute.
In Howrah, within Navarna.
Mr. Banerjee, Howrah, I understand. Is it within 500 meters or not? It is beyond 500 meters. That is the reason why you have given a sanction subject to conditions, right? These are the 17 conditions which you have imposed. They have imposed. You have asked them, they have imposed those conditions, they are there. But as far as the sanctioning is concerned, it has been sanctioned?
No, man.
Not sanctioned. Where is the property? Where's your report?
Yes, they have given the report.
They have given the report, my lord. But I would have handed it over. I don't know why. But it would be something 17th of February 2025, my lord.
No, Justice Chondo asked for a report against these observations. What is your take that they have given?
I have given that.
They have given, my lord.
Madam, may I submit that?
My lord.
I have a copy of the report. Your lordships do not have in the file. I have copy of the.
This is the report.
Yes.
17th February.
17th February.
চন্দ্র বললো তোমার কি বক্তব্য জানো ওরা কি বলছে দেখো ওরা বলছে একটাই হাই there is no scope দেখো
No scope.
সব জায়গাতে বলছে there is no scope this they are saying বাকি there is no scope
15.49 meters বলেছে, so it's not.
বাকি against everything they are saying there is no scope জানলা হবে না কোনো যদি এগ্রি করতেই হয় সিকিউরিটি একটু পসিবল 16 পসিবল 5 আর 16 না 4 5 should not be allowed.
No, where have you said that this is within 100
Last,
meters?
my lord, 1500, no, I have said that sanction, the HMC and OC Sipur police station should keep a clause 17 by.
Yes.
Should keep a close vigil during construction of the building to ensure that the construction is done as per sanction
Mr.
plan
Banerjee, don't
and no
don't
security
try to-
measure gets violated.
Mr. Banerjee,
That I have said.
you are making twofold submission. This is beyond 500 meters.
Well,
That is the
may I
reason you are
make one small
considering it. You are putting all these conditions.
Right.
Today, you can't say this is 100.
That I have not said, but I have said, my lord, at clause 12, that height of the building is less than 15.50.
So, my lord, the notification does not apply at all. It will only apply if it is in excess of 15.5.
That's right.
So, my lord, whether it's within 100, 500 is of no consequence. If it's within 500, then it cannot be in excess of 15.5. Now, in my case, my lord, whatever I have given is less than 15.5.
So let them file the report then.
Yes.
My lord,
But only, my lord, put them on some condition, but from February, my lord, this is going on, my lord. And I am,
Last year, it
last-
is, we are
my
suffering
lord, from
last year.
2000 I have
Just
placed. my lord.
outside my house, my lord, since last year.
That he is, my lord. He's the landlord, my lord, that he is.
I am
cannot
entered,
build it.
my lord,
But
wrongly
I
with the
cannot build
developer.
it now.
Now the consequences, my lord, I am bearing.
Plan submitted on February.
Kindly looks into the conditions, my lord, no windows and, my lord,
Yes,
balconies
no
towards
windows
Navanna.
towards
These
and
sort of
balconies.
conditions.
Towards
In
Navanna,
antecedents of
Then, my
people.
lord, 10 foot, my lord, wall binding.
সেটাই তো
Kindly
towards
they have-
Navanna, kindly appreciate.
But whoever,
Let them file it, but do you know one thing?
my lord, I'm
Mr.
sorry.
Bhattacharya, do you know one thing?
My lord,
That half the building at Samrat Hotel in Delhi is closed. None of the windows can open on the racecourse road.
My lord. I'm grateful.
Conditions can be put. We'll see that. Let them file the report.
Yes. My lord, I could have.
Half the building is not used.
My lord,
On that side.
My lord, with-
I thought-
We will see it.
No, your lordship will see. Anytime your lordship will travels to that, you know, place, even, you know, the elevated corridor, you know, your lordship will see, you know, all buildings around Naman.
I'm not expressing anything. I'm just saying that let them file. If they don't file, how will I decide this issue?
my lord, I'm just beseeching your lordship to give them a short time, my lord, if that can be. And since your lordship is taking,
Let them file an affidavit. A report will not help.
Yes, my lord.
Yes, that's all.
Let them file an affidavit. A report by way of an affidavit might help.
my lord, then also, my lord, kindly, if it falls from your lordship, my lord, the authority may also be disclosed
Yes,
of the
report by.
commissioner. How does he have the authority? Because, my lord, and my lord, first the peremptory direction will kindly, my lord. I know, my lord, for the affidavit is the first direction, but considering so many time has been taken for the report, my lord, let them, my lord, kindly. And I've applied in February 2000, my lord, 2020, sorry.
Oh, I can go with the report also, up to you.
Whatever your lordship be seen. Whatever they want to give, my lord, let them give within that period.
Affidavit.
Let us.
কত? কত?
Learned counsel for the.
10 দেবে তো রে বাবা, ডেট দিচ্ছে।
But 3 weeks is going to take another month.
Take whatever time, you know, let.
No.
Let's finish it.
Yes, let's finish it, my lord.
Let them
Let's
take
finish it.
time. Let's finish it.
Yes, my lord.
Learned counsel for the respondent. Learned counsel for the, what is you are Mr. Basu Malik, you are?
I am for the
Respondent number?
Respondent state.
State.
Two matters, 21 and 22.
States that seeks and is granted further time. States that it will be learned. This court deems it appropriate to direct the respondents to file an report by way of an affidavit. Or we should affidavit in opposition 3 weeks.
3 weeks. 3 weeks.
At the same time.
My lord, 2 weeks, 1 week, my lord, if your lordship.
3 weeks.
They will not file it.
It requires time, Lord.
Affidavit in opposition.
My lord, may I also beseech your lordship, my lord,
Reply
one
to the
thing,
same, if any, within 1 week thereafter. Learned counsel for the respondent corporation is also granted 3 weeks time to file their affidavit in opposition. Reply to the same, if any, within 1 week. List after 4 weeks.
my lord, may I only say this, my lord. I know your lordship has granted them a direction for affidavits, my lord. But would it be your lordship's pleasure also for the commissioner to file a report, because that was specific on the commissioner? Because he has passed this. So I don't know who is going to affirm this.
In my affidavit, Lord, I
The last
cover
order was on
everything.
the commissioner.
Just take down. This court by order dated 25/2/2025 had directed the commissioner of police Kolkata to file a report as to how the restrictions could be imposed in respect of the proposed building, which was outside the security zone. Full stop. Let the report along with an affidavit in opposition be filed by the commission, by the state, full stop. Within a period of 3 weeks, respondent municipality is granted 3 weeks to file the affidavit in opposition. A reply to the same, if any, within 1 week.
4 weeks,
List after 4 weeks.
11th of August, my lord. We have calculated, my lord.
11th of August, my lord, it commenced your option.
Yeah, 11th is Thursday, not Thursday.
No, but if it is convincing, my lord, if it is after 21st of August, can it be possible?
Monday, my
Actually, Mr. Bandyopadhyay is leading us, my lord, up to 20th, my lord, he is in parliament. So 21st, he will, after 21st, he will come and address, my lord.
Sorry.
This is a final stage of hearing, my lord.
No, no, what is this? This is
11th August is a Monday, my lord.
we can have it on 10th of 11th August is a Monday.
Monday.
Session starts, my lord.
We'll have it on 11th.
Grateful, lordship, when lordship? 11, grateful.
You are good enough, Mr.
He is here, my lord.
Asumati.
My lord, will be your lordship's pleasure to keep it at 2 p.m.
Let's not fix it.
My lord, same heading as respect to item number 22 also.
And then let it, if it could remain in the same heading, my lord, if it's possible.
It has to 22 minutes together, the same order.
Very grateful, my
Same
lord.
order. Same.
Same heading.
Same heading.
There was also a direction for the commissioner to file a report.
One by the landlord, one by the developer.
Wait a minute.
Same order, my lord.
কি আছে মোশনে আছে
হ্যাঁ মোশনে যেন থাকে
No, इसमें वो commissioner हटा दो. Remove the commissioner, affidavit and opposition. There's no direction for commissioner.
Yes, the direction was in both them.
No? Where?
25th February. The server copy of the order says,
No, sir.
with respect.
It's one single order, my lord.
I don't have that copy.
Kindly see. How is it possible or not?
Then the same order.
Yes.
Lord,
Same.
issue is the same.
I'll keep this one.
My lord, please.
Keep it up.
My lord, under the heading motion, my lord, kind.
I know, heading motion.
Grateful.
Grateful.
অ্যাফিডেভিট আসা দরকার আসুক অ্যাফিডেভিট হলে ভালো হবে কত আছে they cannot find
My lord, grateful.
that what শুরু করতে হবে শুরু করতে হবে।
But Mr. Chakravarti, do your research. Search on the judgments, see the powers of the corporation.
Yes,
See
yes,
the
yes,
power of
yes.
the.
My lord, my lord.
My lord, we have those.
We have those even today. I
The
do
local
not-
authority or anyone else wouldn't have.
Yes,
My lord,
yes,
grateful, my lord.
but extremely grateful to them.
Item number 23, Lordship, I'm for the petition. Lordship, the petitioner does not want to proceed with the matter. So they gave me a written application and they have
All right.
My lord, I am there for the KMC in the original side matter tagged with this appellate side matter.
Where is? Both the matters? Both the matters are yours?
Yes, Lord.
Both are your matters?
Yes.
Both you are withdrawing?
Yes.
এই তোমার দুটো কেন দুটো মামলাই তোমার
একটা WP
এইটাই তো just clear করছি দুটো তোমার কেন?
না দুটো না Lordship, the appellate side matters is of the appellate side of matter WPA 2833. I am the advocate on record.
And the other one?
The other one, I don't.
Who's the lawyer in the other one? Ask your. This Mehtab has filed both the petitions. No, who has filed that? Shahid Ahmed?
Zainab Tahur. Zainab Tahur. One Miss Zainab Tahur.
All right, we'll dismiss this one. Dismiss as withdrawn. We'll see the other one. Learned counsel for the petitioner states that hands over a copy of the instruction which he has received from his client. Full stop. He states that his client does not wish to press the present writ petition. He seeks to withdraw the present writ petition. The same is dismissed as withdrawn. No, just one. Nobody is here for the other matter. Nobody is here. Huh?
My lord, I am for the corporation in that original side matter.
None appears for. I'll just mark it. Then what is the point of keeping it here? Then we'll send it to the original side.
My lord, as your lordship pleases.
What is the issue?
My lord, the original side matter is for implementation of a demolition order, and the appellate side matter was for praying for a stay of the demolition order.
So now he's not praying for the stay of the demolition order.
My lord,
So
it
the
appears
demolition
so.
can be done.
It's always already a direction of this honorable court to execute that order.
Put it on the you'll see it. इसको original side में वापस भेज दें क्या? हाँ. हाँ. In item उसमें लिख लो. The present petition was tagged along with writ petition number so and so, since in writ petition number so and so, the petitioner had challenged the demolition order of the same property, wherein in writ petition so and so 470 of 2024, the petitioner has sought the execution of the demolition order. What is the date of the demolition order, madam?
My lord, just demolition order of the special officer building is 22nd of April 2019. In the original side petition,
22nd
it
of
is
April.
annexure P8 at page
Yes,
35.
22nd of April. Yeah, demolition order लिखा है ना? One dated 22nd of April 2000. Since the petitioner has withdrawn writ petition number 2833 of 2025, wherein he had sought challenge to the demolition order passed by the respondent. The other writ petition so and so is detagged and listed in its original position on the appellate side, on the original side. Sorry. Original side in the automatic.
Lordship has made any date for return of that matter?
Let it go in its original position.
My lord. I'm grateful, your lordship.
I am for the corporation. Howrah Corporation. Petition?
Private.
দাঁড়াও দিচ্ছি।
I am appearing for the private respondent number 6.
Who is the petitioner? You are appearing for?
Private respondent number 6.
You're the one constructed the property, all settled.
Yes.
And kindly have a look to page 16. There is an order passed by the coordinate bench with a direction upon the authority to take decision after giving an opportunity of hearing. So till date, this order has not been complied with by the authority. Let the authority comply with the order by giving opportunity of hearing to the
Extra 3 floors, my lord.
Nobody's here. Do whatever you
My
have
lord,
to.
petitioner is not present. I am sorry, my lord, I have to say that these things are happening. When there is a hand and gloves between the private respondents, they withdraw the petition or get it dismissed for default.
That's the problem, but you can always take action.
If your lordship directs for dismiss for default, my lord may grant us liberty to.
Learned, none appears for the petitioner.
My lord, kindly have a look to page 16, my
Now
lord.
they will.
The one order is there passed by this Honorable High Court that has not been complied with.
Yes, everything has been complied.
There is direction.
If
upon the
not
authority to-
complied with, please file a writ petition for compliance of the order. This is not your writ petition. All right,
My lord, kindly have a look to page 17, the last paragraph.
sir. If they have not complied with, file a writ petition, challenge the demolition order, do whatever you have to do.
But till date, my lord,
You are private respondent.
private respondent.
You have your remedy in law. Avail it. All right. None appears for the petitioner. The present writ petition has been filed seeking implementation of the demolition notice dated 30th October 2024 and 9th January 2024, wherein it is stated that the entire property has been constructed without any sanction plan. Though there is no appearance on behalf of the petitioner, the Calcutta Municipal, what is this, Howrah Municipal Corporation is at liberty to proceed in accordance with law
But before taking step, my lord, let me file any objection.
as
before the
deemed
authority.
fit. As deemed fit. Full stop. Learned counsel for the respondent number 1 states that respondent number 6, you are the builder. Respondent number 6, the private builder states that he has not been given an opportunity of hearing.
We denied that apartment. Submission.
The order is there.
We deny.
There is a
Yes, yes,
direction.
we have given
Let them, let my learned friend submit that they have complied with the order.
Has
show that.
not been granted opportunity of hearing at the time of passing of the
Immediately they come for hearing.
reviewed order. Learned counsel for the respondent is always at liberty to challenge the order, the demolition order in accordance with law. Full stop. Since the petitioner has
But demolition order has not been passed till date, my lord.
demolition order has been passed.
Demolition order has been passed, madam.
Just show
That
me.
is page. I'm
You
sorry.
can say- These order has not.
Which page?
That is at page, my lord, 24. They have been directed to take immediate self demolition of the building. They have not, the private respondents have not proceeded against that. And now in the petition of the petitioner, now they come and say that we should be given a hearing. Every hearing, it is a must that hearing is given.
But a hearing
Now-
in compliance.
Sir, you file your petition.
No, my lord.
Why have you not filed it? If you are so aggrieved by the order, file your petition. क्या लिखा है?
In compliance with.
Yes. With the above direction, the present writ petition is dismissed for non-prosecution.
The entire building is without a sanction plan.
My lord, by an order of 7th of February, my lord, there was a direction for the corporation to file a report in the form of an affidavit.
Yes.
That is.
Yes. Madam, you are appearing for corporation.
Yes, Lordship, but
See the order,
Yes.
7th of February order, right?
Yes.
7th of February.
a tin shed on the roof, whether it can be subject matter of demolition.
Learned counsel for the.
Yes, Lordship, this is our report. Lordship, there was some.
Report by way of
With
an
the form of
affidavit. Madam, at least read the order.
Lordship, kindly give me some time so that I can.
Learned counsel for the respondent, Calcutta Municipal Corporation, seeks and is granted further time of 2 weeks to file her report by way of an affidavit as directed by this court by order dated 7/2/2025. Full stop. Exception to the same, if any, within 1 week thereafter. The stay is still.
That's in fact expired. I mean, if your lordship could reimpose it, Lord, and keep it for another 3 weeks.
No one is taking any action. List after 4 weeks. 11th August.
My lord. Lordship, those judgments, Lord, I had handed up to your lordship's officer.
Oh. Give it to me. I'll have it. Thank you.
My lord, I am appearing for the petitioner. I am for the petitioner, my lord.
The ability to option on behalf of the.
This is my reply, my lord. My lord, the grievance of the petitioner is that petitioner's husband expired 1 year prior to the date of retirement. Thereafter, no family pension. After filing of the writ petition, PPO was issued. Family pension initiated in the month of April, but the arrear pension not given. In their opposition, they have said the gratuity amount would be paid, but it has to come serially. The serially, if your lordship kindly sees in their opposition, that I am placed at last, but from serial number 127 to 134, the PPOs they were issuing just before the retirement, and in my case, serial number 136, page 29, they are issuing it in 2025, and my husband expired on 2022. So my only prayer before your lordship is that they should disburse the gratuity amount within a time period and the arrear pension in a time-bound period. This is my two prayers, my lord.
Yes. In the case of family pension, that the deceased husband, the petition was filed before the issuance of the PPO. The
Yes.
petition filed on 2nd February 2025. PPO was issued on 27th February 25. And thereafter, the pension has been started from the month of March. And first payment was made on 7th April. For the
Yes.
month. But kindly see page 23. Kindly see of my opposition.
Yes.
Lordship, CL number 110. Last. Suparna Kundu, petitioner hearing, is getting pension 30,026 rupees.
Yes.
Then the provident fund has been paid.
I'm not disputing that.
Next page. After 1,63,596, and then 2 installments. 3 lakhs. Next page. Can you see? 25. Page 25. 3,53,907. Now, so for the gratuity in question, the fact is this: as per ROPA 2009, the municipality has been paid. Thereafter, the government has enhanced that gratuity without paying that out, violating the section 23 of subsection 4 of the Jail Budget. But however, the municipality has been paying from its own fund as per its capacity, because the government does not. If the government paid the gratuity amount within a day, the municipality. But the government does not pay. So municipality, as per their capacity, paying. Let the kindly see page 26, page 26, annex R7. Not the Provin Kumar Go 0000, all are paid. And initially, by installment, the municipality is paying from its own fund. Government does not pay. That is the difficulty. The gratuity payment is not paid by the government.
My lord, kindly come to page 29.
Yes.
So if you are
At
not
29.
the government to pay the gratuity amount, the municipality is ready within 24 hours to disburse that amount.
You appear for the government. You
Yes,
filed your report.
I shall take instruction, my lord. I am taking 7 days time, my lord.
List after 2 weeks. You file your report. Why you're not paying your part of the gratuity?
No, I shall take instruction, my lord.
Report is
My lord, order may be directing to file the report.
Learned counsel for the state seeks and is granted 2 weeks time to file his report by way of an affidavit indicating the amount of gratuity which has been released in favor of the municipality.
My lord, as well as they should take instruction regarding, because they have not said what is the area amount they would be paying, because they have not stated in their opposition area pension. They should take instruction on that also, the municipality.
We'll see that.
Not kindly kept in my record. My affidavit in opposition filed by the municipality, kindly keep.
Yes, affidavit opposition filed by the municipality is taken on record.
And the reply.
Reply to the same is also taken on record. उससे पहले एक line लिख देना. Learned counsel for the municipality states that the municipality has been paying the gratuity amount from his own resources. Full stop. He further states that the state has not contributed any sum for the gratuity disbursement. Full stop. उसके बाद कहते हैं learned counsel for the respondent seeks and is granted learned counsel for the respondent seeks and is granted 2 weeks time to file his report by way of an affidavit.
Grateful, my lord.
2 weeks, 2 weeks.
2 weeks.
And कब का
ये डेट तक होगा? 28. Minimum report state के.
A report by the state, a reply 1 week, list after 4 weeks. After 4 weeks.
7th August. After 4 weeks,
7th. 11.
Yes.
Not yet called.
I'm for the municipal court.
In this matter,
Tomluk municipality. I am
It is
praying
27,
not
I
to
appear
the
for the
Lord.
state, my lord.
you're appearing for Ms.
Tomluk
Sadas.
municipality, yes. I am for the private respondents.
I am for the petitioner in this matter. I believe, my lord, your lordship kindly allow me 1 minute time. But and here my innocuous prayer before lordship. Lord, in this writ application, I have come before this court alleging that in spite of allegations made by me for unauthorized construction by the private respondent, municipal authority has not taken any steps. My learned friend appearing on behalf of the private respondent has filed an affidavit stating to the effect that his client is making the construction of a tin shed on the 2nd floor. But in fact, he has purchased the 1st floor of the building, which I constructed with due sanction plan of 1997. But I have sold the 1st floor only to him,
No, my
to my client.
Just a minute, madam.
Complete kori, madam. So what I want, he is saying that I have made unauthorized construction. I am saying they are making the unauthorized construction. So what I am praying before lordship at this stage, your lordship kindly direct the municipality authorities to file a report before lordship. After perusing the report, my lord will pass necessary order.
My lord,
The authority will inquire and give report to my lord. Who is making the construction? What type of construction is there? Whether that is as per the plan or not? Whether they have taken the plan or not? or I have made construction, illegal
Mr.
construction.
Manna, there's already a direction on 8th of April
Yes,
for
I
the
don't-
municipality to file an affidavit in
yes,
opposition.
my lord, I have filed my.
He has filed, but the state has not. Corporate.
Only between the parties.
No, no,
Parties.
you read, learned advocate for the respondent municipality as well as the private respondent seeks time to file their affidavit in opposition.
Yes, my lord, I have filed my affidavit.
Both.
my lord.
I have given reply to that effect.
Yes.
Lordship, municipality has nothing to say.
Nothing to say, you have to
Nothing
decide.
say.
Lordship, all kindly come to page number 56, already taken steps.
56.
Lordship.
Yes, my lord.
56, yes. But they have, this is also my case. That as there is no sanction, they have given notice to stop work. Then your lordship kindly have a
Put your
look
stand.
to the photographs annexed
Learned counsel for
My
the,
lord, kindly.
at page,
look into my
page
op-
50, 62.
wait, madam.
My lord, kindly have a look.
Pakka construction is
My
being made.
opposition.
Mane, if it is made by me, your lordship kindly order to demolish it.
There, man,
My
no.
lord, kindly, my lord.
Sorry, ma'am.
Let me to place my case, my lord.
You don't need to place your case.
Yes, my lord.
No,
I-
not right now, madam.
Already in.
Madam, not right now.
Oh, yes. Then, my lord.
Super excited.
My lord, a report has been sent by IC Tomluk. May I hand up?
Yes.
What does the police authority got to do with construction?
My lord, a complaint has been filed and
Yes.
steps
Very
have
good. Put both of them behind bars.
Regarding construction,
been hand up.
municipality is the authority to
Madam, keep it.
give report.
Give your appearance.
Well, he has also made.
Learned,
Yes, yes.
counsel
Let
for
it
the
be con-
respondent,
demolished.
Ms. Ananya Das for the Tamralita municipality seeks and is granted further time of, how much time, madam?
Lordship.
How much time? 2 weeks? 2 weeks to file her affidavit in opposition. A reply to the same, if any, within 1 week thereafter. 1 week or 2 weeks?
If required, I will file the opposition to the affidavit used by the municipality within a week thereafter.
1
Huh?
week thereafter, list after 4 weeks. 12th August.
My lord has
Don't
state
keep,
to file.
Probably
don't keep all matters on one day. 12th August.
4 weeks.
12th. 11th बहुत matter रख लिया ना. अब 12th करो ना. Should divide the matters.
12th August.
Otherwise, too many matters will be on one day. Just keep a tab of it. When you give dates,
So private
Because
response.
the report which the IC has been given, can a copy of the same be given?
I'm not keeping it. Why should you?
Oh, yes, your lordship has not taken this consideration.
Lordship, for 28, I am for the private respondent led by Mr. Mohit Mukherjee praying for short passover, my lord.
Lordship,
He's
ask
on
for
his
what?
leg in
4:30, you ask for a passover.
my lord, he is on his legs in courtroom number 28, my lord. That's a matter going on there.
NKD is the answering respondent in this matter.
No, I beg to appear on behalf of the inquiry.
NKD is represented.
Not today.
My lord, short.
Wait for Wednesday. Madam, look at the time.
My lord,
My
can you
lord.
taken up on Wednesday?
Wednesday.
I'm grateful.
Great.
I am for the private respondents.
For the state.
Number 4.
Yes.
But I am for the private respondent.
Petitioner. None for the petitioner, dismiss in default. Dismiss in default.
What opposition goal? All of the
Opposition. ভালো করে বুঝিয়ে লিখে দিতে হবে।
I am for the petition, my lord. It's also an extension of interim. But here, my lord,
The report has come to me, but I find, my lord, 25th of February of this year, my lord, the direction was passed, my lord, dealing with these allegations, and affidavit dealing with these allegations. But the affidavit has not been made. It is just inquiring what is the order passed earlier by the court. I find the affidavit, my lord. Therefore, the report, my lord, I want to place it because since it is not by an affidavit, you know, my lord, grants me some.
it was an affidavit. If your lordship kindly come to the order dated.
Affidavit means affidavit in opposition, I can file also affidavit in opposition.
The corporation is directed to file an affidavit disclosing its position in response to the allegation raised in the writ petition.
All right. Learned counsel for the respondent, Calcutta Municipal Corporation. Mr. Ghosh seeks and is granted further time of
2 weeks.
2 weeks to file his affidavit.
And reply, my lord.
Affidavit as directed by this court by order dated 25/2/2025. A reply to the same, if any, within
2 weeks, reply within
2 weeks thereafter, list after 6 weeks.
Well, a matter will appear, my lord, after
6 weeks.
After
6 weeks.
I'm grateful. Well, an interim order may be continued, my lord. I have also filed an application for interim order, which is, my lord, can 1 of 25.
Let it be for a limited period because
Then
that was also the limited period.
Yeah.
That
What,
is why
what
I
is,
filed
what is the matter?
application
Mr.
for
Ghosh?
extension.
5-story building today unauthorized here.
Yeah, I
it's an issue.
satisfied your
Then
lordship.
let's
It
finish
is
it
not
off.
my building.
Just a minute.
Well, I raised an issue, he has raised an issue. Of course, but he
Mr. Ghosh, file a affidavit in 1 week. Let's finish it off. I don't want to extend his interim order for 5 weeks.
ঠিক আছে, যা করো করো। ওর ডাকো। রিপোর্টটা just এখন নেবে না তো, এবিডিটি লেখা আছে না? My lord. 10 days zero grant.
6 and is granted 10 days to file his affidavit as per the direction of this court by order dated 25/2/2025. Reply to the same, if any, within 1 week thereafter, list after 15 days. After 17 days listed. क्या होगा 17 days के बाद? First August is a Friday. 1st August.
First, very well. Until such time, you kindly extend the interim order, my lord.
The interim order has already expired, sir.
Well, I have filed an application for extension, my lord. That is, my lord, can CRAN, my lord, CAN, my lord, 1 of 2025.
আমাকে petition কোথায়?
When did you file it?
Petition কোথায়? আমাকে কই দিস?
Well, Lord, it was filed, my lord, in April 25, my lord.
আমার petition কোথায়? কপি কোথায়?
Can one
কোথায় কেউ?
আমি দিয়ে দেবো।
seeking extension of the interim order granted by
Well,
order dated
25th
25
April it was filed.
25. Is disposed of.
Can আছে?
The interim order granted by order dated 25/2/2025 is further extended for a period of 3 weeks
3 weeks.
কপি দাও আমাকে একটা।
or until further order.
কালকে
Give a copy. You have not even.
I shall definitely, sir, my lord. I shall definitely.
How do you file things without serving?
But I don't know why that. I shall definitely, sir, my lord, within tomorrow. My lord. I'm grateful.
In this matter, my lord, an order has been passed by the honorable coordinate bench, but that has been carried forward before the honorable division bench by the petitioner herself. Thereafter, my lord,
Private response.
themselves. Thereafter, my lord, the Honorable Division Bench has been pleased to dispose of the appeal, allowing the appeal, and also passed an order that a writ petition will be disposed.
Writ
Order-
petition will be disposed of.
Yes, my lord.
Where's the order?
Order I have to place. I have just came to know. If you
Then it has become infructuous, sir. You withdraw it. You are aware of that.
Mrs. Devjani Sengupta is appearing, my lord. Yes, my lord. On 1st July, writ petition has been disposed of,
automatically it has become
dismissed
infructuous.
by the. Yes.
You should withdraw it. Why are you? You are the advocate on record.
No, my lord.
Who's the advocate on record?
Devjani Sengupta.
Where is she?
But she is, my lord.
Sitting outside enjoying the weather.
No.
If your lordship keeps the matter tomorrow, then I will come with the order itself.
Tomorrow, not
Fine.
today.
Order গুলো নিয়ে আসবো।
Sure.
Order গুলো বার করে রাখছি।
এইটা
But I happy for the state.
operation, my lord.
Yes, you give necessary direction.
My lord, there is a dispute with regard to water supply, my lord, to the tenants as far as.
The officer in charge, Garden
my lord.
Reach
Yes,
Police
yes.
Station shall visit the spot
Yes, yes, yes.
and give necessary direction to the landlord to ensure smooth water supply.
Yes, my lord, that has been done.
Done?
Yeah. This is my report, lordship. May I kindly have it
Dismiss in default.
dismissed for
This
default.
state too.
I'm state though. My lord, I am for the state, my lord.
The direction is to you only.
Yes, yes. We have carried over the direction.
Dismiss in default. None for the petitioner, the matter is dismissed.
And I appear on behalf of the Malad. There was a tap, my lord, within my land. On the corner of one portion, my lord, there was a tap. It was not in use for last 15-20 years, my lord. So the local residents, they started demolishing capturing that land. So the petitioner, my lord, after they started encroaching, my lord, the petitioner wanted to give a boundary wall over the land, and then they started this problem, my lord. We wrote to the chairman of the municipality, my lord, Balurghat municipality. No action was taken, my lord. I went to the this SDO also, but no, my lord, action has yet been taken, my lord.
So go to the civil court, sir. What are you?
My
what
lord,
is this?
since the the municipal corporation is the
Is
tap
there
was,
an authorized construction? What tap? Where is the tap?
my lord, it was on my land.
So what happened to the tap?
My lord, it was not in use
Where
for
is
last,
where is it stated? What is your prayer?
my lord.
All your private dispute, civil dispute, you file a writ petition.
No, my lord, the tap was supposed to be, my lord,
Sir, where is your relief?
my lord,
Read the prayer clause.
my lord.
Unlawful encroachment.
And
What
that
unlawful?
is done by that is done by the municipality, my lord. Baluran municipality has done it, my lord.
What unlawful encroachment they have done? Tell me, sir.
My lord, the tap which is there, my lord, that was on my land, my lord.
Sir, please show me from your pleadings.
My lord. My lord, kindly come to page 6, paragraph 6, my lord, page 5, my lord. For the past 8 to 9 years, the said tap has been completely non-functional and abandoned, rendering it of no use to the public. Neither the municipality nor any other authority has undertaken any maintenance or repair of the said tap. As a result, the portion of the land where the tap is located is lying unused and vacant and unused, my lord, with no public purpose being served. Given the lack of any municipal or governmental
Very nice.
intervention, my lord.
Wow. Look at what you have written. Given the lack of any municipal or government intervention,
Lord,
the
we
6
have
portion
written-
of the land has reverted. It reverts back to you.
My lord, since my lord, it was within our, my lord, the tap
Sir,
was on.
do not come for these kind of petitions to this court. All right? Don't file these kind of frivolous petitions in this court. You want to withdraw, or I'll dismiss with cost. Land disputes reverts back to you. Very nice. Petitioner seeks to withdraw the present petition, dismissed as withdrawn. The heights of pleading and anything. Next,
Grateful lordship. I appear for the municipality lordship.
land reverts back to people.
So,
Without going to court, land reverts back to you. Please, sir, don't open your mouth also. Don't file petitions like this. Give the next matter.
obligation.
আমরা দিয়ে দিয়েছি ভোটকে দিয়ে আপনাকে দিয়েছি
Yes, Mr. Mitra.
This is my affidavit in reply, madam.
Hearing matter, my lord, can it be taken up Friday, man?
All right.
I have to
Friday?
study at least something. Affidavit opposition reply complete. Only Friday.
What is this, Mr. Mitra, you're handing over?
My lord, our grievance is, my lord, that the Howrah Municipal Corporation abruptly enhanced the license fee, but to an exorbitant amount. That is not permissible under the law, and that too without giving any opportunity of being heard to the assessee.
I will show that is permissible under the law. And
That I should deal
opportunity
with.
have been given.
This is your reply.
Reply, my lord.
Reply on behalf of the petitioner to the affidavit in opposition is taken. Affidavit in opposition by respondent number 2, 3, 4, 5 is taken on the.
Opportunity not being heard. Not to পড়তে দিন না।
Friday, or you want to do it
Friday. I think
next week?
by next week.
Next week I have difficulty. Then we'll have on 25th or 26th.
20?
Which one suits you, Mr.
25th of
Mitra?
April.
20th.
25th of July. As well as
Yes. No, not even, sorry, not 25th. 28th of July.
28th of July.
My lord, it will retain its position, my lord. It is item number 1 in the hearing list.
No, no, one করবেন।
One, it can't be.
No, another heading hearing, my lord, it is at the top.
আরে আমাকে মোশনে দিচ্ছে তো।
It will come, sir. Problem is you don't appear in my court regularly.
Hearing করতে চাইছেন?
Matter will come. 28th.
28th.
Twenty-
Obliged to.
28th. 28th month.
28th.
Grateful, man.
Your Lordship, I'm for the petitioner. I'm being led by Mr. Sudhashatto Banerjee, Your Lordship. He's on legs, Your Lordship. Kindly keeps it tomorrow.
But not tomorrow, lordship. Not
When do you want? Day after?
Yeah.
Wednesday.
grateful.
Yeah. Monthly list. None for the petitioner. In the interest of justice, adverse orders are deferred. We'll not dismiss in default. One opportunity, after that we'll dismiss it. These are all matters pending for last 2 years. One opportunity, and then after that we'll see. None appears for the petitioner. We'll keep it tomorrow. Okay.
Well, I appeal for the response.
You're appearing for?
No, in item 70 I was there, my lord.
70 you were there for the?
70.
You were there for who?
The respondent, my lord.
Give your appearance. Mark his appearance. 71.
তোমারটা তো বলে দিল জাস্ট
Same order kar lena. I'm just trying to take these old matters and
70 then and day after tomorrow.
all 71 also day after tomorrow. We'll just roll it out so that we can finish it.
সত্তর নামটা দিয়ে দাও।
For 2 years there has been no hearing.
আগে ডাক।
The rest of the matters we can have tomorrow.
Well, 72 অবধি হলো?
The Mr. Ghosh, 2 years, these matters have not been taken up.
Yes, yes.
We'll try to roll it out so that we can.
That's not good.